I feel no, but we were gonna send a couple people and take them from you.
Testing the microphone. Microphone test, test, test.
Ready, Jess? Well, good afternoon, everyone. I'm gonna blind myself. Welcome to the WATCP statewide conference. It's very excited that a lot of you are here in person, a lot more than last year. So that's good. My name is Heather Kierzik. I'm the statewide problem solving court coordinator out of the Director of State Courts office. I'm gonna have my cohorts here introduce themselves, and then we'll get started on some standards training.
Welcome. I'm Marcia Shizik. I'm a TAD program specialist with the Department of Justice.
Good afternoon. My name is Mike Durr, and I'm the TAD Program Improvement Specialist. I've been on board for about the last 11 months now. Prior to that time, I worked in the Department of Health Services as the SABG grant planner. So some of you might know me from that role. So it's good to see you all.
Good afternoon, everyone. My name is Kimberly Kitzberger, and I am the president of the Wisconsin Association of Treatment Court Professionals. I am also a treatment provider in St. Croix County with previous experience on both the St. Croix County Adult Treatment Court and OWI Court.
And as we go through this, we encourage you guys to ask questions. Do raise your hand though, and we'll come to you with a microphone so the people that are watching us online can hear us. And also the people who are online, if you have questions, if you just want to put them through the Q&A, and Jess will let us know that we have some questions online and we'll answer those if we can, hopefully. All right, so Kim's gonna get us started.
I don't know how I'm going to balance all this. All right. How do I make it advance, Jess? I don't know. That's a way to start. Okay, that works. I just need to tell you. Okay, that's less for me to balance in my hands anyway. Perfect. So let's go ahead and dig in with standard one. If you can advance the slide, Jess. Okay, standard one is all about demonstration or demonstrated commitment to evidence-based practices. By the end of the next 4 days, you'll probably learn to love, hate the word evidence-based practices if you don't already. Evidence-based practices really lays the foundation for what it is we do here in treatment courts. Go ahead, Jess. So treatment courts themselves are, in fact, an evidence-based practice. In the criminal justice system, this just simply refers to a partnership between research and practice. So you'll see the diagram shows sort of the cycle of what this looks like in our system. Basically, research informs our practice. What we do is based on standards. What we do is based on a model. What we do is based on research. The practice then informs your outcomes. What are the outcomes these practices are producing in our own programs? And then, of course, outcomes are measured by more research, and it just kind of continues. Treatment courts are based on the R&R principle, which we will talk about in great depth throughout the standards today. Excuse me. What's most important here to understand is that we want to match, excuse me, go back to my notes, not ad lib here. We want to match the level of service to the individual's risk. And the risk that we're talking about here is the risk of reoffense or risk of recidivism. What's really important to know is that risk is contagious. You've probably heard this before. If we mix our risk populations, if we put folks in our programs that are low risk with folks in our program that are high risk, we will actually make those who are low risk worse. We will do harm. We will increase their risk while likely not changing the risk of those that are high risk. Also, what's important is the high risk participants are those that require the intensity of service that we provide in a treatment court. Low risk folks usually need minimal intervention, quick intervention, move them on. There's some self-correcting factors that come in with the low risk population. Then we talk about the need principle. In treatment courts, we're focusing on needs that are best defined as criminogenic needs. The big four needs are the ones that we focus on most, as these are the needs that, if left unaddressed, will cause higher rates of recidivism. So the big four are those that are linked to criminal recidivism. Then we talk about responsivity. Responsivity really is applying to the needs that might become barriers to participants finding success in our programs. Factors that impact their ability to meet their treatment goals. A good example here is if we put somebody in treatment who is not yet motivated to be in treatment, treatment is going to do very little. So instead, we have to focus on what can we do with this individual to increase or improve their motivation for entering treatment before we place them there. So some of those pre-treatment services, some of those stages of change type services, bring them along in that stage of change without just expecting treatment to solve those problems. Sorry, guys. So this is how we match all of those interventions. We're targeting the various interventions that we provide to each of these principles. So we're looking at supervision and treatment resources for high-risk participants. We're taking a look at how are we going to address those criminogenic needs. We're also going to be responsive to those responsivity needs, things like learning style, motivation for treatment, gender, how gender impacts one's ability to be successful in the programs that we provide, and culture. In a treatment court setting, because we're dealing with folks determined high risk, high need, we also talk a lot about dosage. And one of the pieces of research suggests that for folks that are coming into the program, we need to structure their time. And we need to structure 40 to 70% of their time for 3 to 9 months, teaching them those skills, keeping them busy, helping them avoid trigger situations. And then, of course, we want to make sure that treatment is a part of the discussion when we're talking about responses to behavior, including those sanction pieces. We always want to be looking at what kind of therapeutic or treatment-based adjustment can we make alongside of any sanction that needs to be imposed. Just a little, some research again about this R&R principle. Again, we talked about if we start mixing populations. This research is based out of some data from a halfway house in Ohio, where all populations live together. So you had folks who were screened as high risk, moderate risk, and low risk, and look what happened to those low risk folks. You saw some reductions in recidivism among the high risk and moderate risk, but we saw only an increase in those that were determined low risk. So again, wanting to make sure that we're screening our participants appropriately. We're only taking in folks who fall into those high risk categories and doing what we can to move those low risk participants into different diversion type programs. And then, of course, with all that we want to do, we want to make sure that we're having a trauma-informed approach. I wrote something down and it's on my other piece of paper. What does it really mean to have a trauma-informed approach? It means a lot of things, but these down in the blue box, never assume the reasons for one's behavior. There's usually many factors that drive the behaviors that we see from our participants, especially early on. And some of that might just be survival, the way that they had to live to survive in the world that they knew before you took them into your program. We want them to understand that we're here to understand their behaviors, not judge their behaviors. We're here from a place of understanding, not a place of judgment. We want to build this in with every interaction that we have with participants, including those from the bench, which isn't always easy to do. But that helps create that safe place so that they can be vulnerable and try a new skill, try honesty for the first time. I think that's probably the biggest headache we hear about in treatment courts is what do we do about dishonesty? How do we respond to lying? And it certainly needs to be responded to. But when somebody takes that first step of trying honesty for maybe the first time, that's a really big thing. That's a big accomplishment in your courtroom or in your office or in your treatment clinic, whatever setting it may be. Before we move into standard 2, any questions or comments about evidence-based practices? And again, in the room, please remember I have to bring the mic to you so that those who are joining us virtually can hear the questions. Also, I'll make a side note for those of you in the room, we did ask that the heat be addressed. There's a lot of us in here, but we're working on it. Questions on evidence-based practices? Anything in the chat? All right. Anything I missed? Okay, but now my notes are all out of order. Uh-oh. Moving on then to standard 2. This is another standard that you will hear plenty of about in the next 3 or 4 days, however long we're together. And this is a standard that I will tell you most people roll their eyes and wonder why the heck are we continuing to hammer this home. Equity and inclusion is something that is not only important, there's tons of research about it in treatment courts, but if we don't take the time to take a look at how our policies are affecting those who would be considered minority populations or those who have experienced discrimination in any form, particularly within our system, we're only perpetuating that behavior to continue system-wide. So WATCP has taken, it's our mission, it's part of our mission to make sure that with every training we provide, we focus some time on equity and inclusion. We've done a lot of research in the last 1.5 years within programs who have volunteered to put their data forward to help us identify where some of these issues or concerns may be arising. And I will tell you, you will hear about it again and again in these next couple of days. I broke it again. Sorry, guys. For those of you virtually, we're just experiencing a technical difficulty with the clicker. Just give us a few minutes here. You want to manually advance them again? Okay. Okay, so when we're talking about equity inclusion, we're talking about making sure that the program creates equal access by using things like referral and eligibility criteria and screening and assessment tools that are non-discriminatory in intent and impact. They're also objective, measurable. You can measure them across every applicant to your treatment court. Okay. Now you're one too far. Yes, thank you. We also want to make sure that we are looking at things like the appropriate level of care. This is treatment terms, appropriate level of care and quality in our treatment. What about taking someone into our program who we don't have services available to meet their needs? What are we setting that individual up for? The other place where we talk about equal access and something that the Department of Justice and our colleagues here have been working on quite a bit, especially if you're a TAD funded program, a Treatment Alternatives and Diversion Grant funded program, is procedural fairness. Procedural fairness surveys go out once a year, that you forward on to the participants in your programs, and they provide feedback that goes down to the Department of Justice about their perceptions of how all team members are treating them, their right to be heard in court, many different questions. And then our folks down at DOJ put together that information, make sure that confidentiality and all of those pieces are still secured, and send that back to your program so that you can monitor your data in terms of how your participants feel they're being responded to and treated in your program. That gives you a lot of quality information about places where you might need to take a look at, are your practices setting up some folks or groups of folks for different outcomes? Now we can go to the next one. Okay, sorry, recognition of implicit bias. This is probably one of the hardest things that we ask practitioners to do, and that's simply awareness. Be aware of your own beliefs, your own practices, things that might get in the way and create barriers, whether they're subconscious or not, to folks' success. And oftentimes we don't know what we don't know, right? So there is a tool down in your packet of slides when you can access these that Harvard does. Basically, it's called an implicit bias test. And you click on it and you can measure your own implicit bias for different subgroups. And what it does is it flashes words up on the screen and it has you click one or the other. And it goes over and over again. And then at the end, it sort of rates how you put groups or you matched certain qualities to certain groups of people and helps you bring awareness to where you might have some implicit bias on certain subcategories or groups of people. I did this a couple of times and it breaks it down by religious group, gender, racial groups. And it was quite eye-opening. Some things that I thought, no way, I wouldn't look at this, but based on the testing, it certainly raised my awareness. And that's all we're asking for here is raise your awareness and keep those things in mind when you're working with folks in your treatment court. Working? We think? Okay. Well, this is my last slide, so I'm not going to touch it, and we'll let somebody else touch it before I pick it up again. Okay. And really the important piece when you're taking a look at equity and inclusion is, again, awareness. Take a look at what's happening within your programs, identify where issues might be occurring, and then do something about it. Do something about it. Again, we'll talk about data on all those pieces, but collect the data, review the data, and make a specific plan for addressing those areas. As I mentioned when we started this standard, if we don't do this within our programs, the impacts to the criminal justice system as a whole are significant. So one of the best questions I think that we can ask ourselves is, how does our treatment court population compare to our jail population? If 80% of your jail population identifies as African American, but only 20% of your treatment court population identifies as African American, where are we missing those folks? How are they falling through the gap? And that's easier said than done. I work in a border county, right? And being a border county, we have a lot of folks in our jail who are not residents of our county. That changes our jail population. That changes our treatment court population. Certainly we have to take those factors into consideration, but for those that would otherwise potentially be eligible, they're resident, at least eligible to be screened, we should be looking at why are they in our jails and not making it to our referral list, right? And then of course, another important piece of this is continuing education. Research is coming out on equity and inclusion all the time. It's sort of one of those hot topic issues right now. National partners are doing a ton. The state is doing a ton with the procedural fairness. WATCP will continue to push forward our own efforts on educating about equity and inclusion and sometimes having those difficult discussions. But as difficult as they may be, they're super important, and we would welcome your teams to have some of those discussions, maybe even by taking that implicit bias test and talking about some of your results within your team, if it's a safe place to do so. Before I hand it over on standard 3, questions, comments on equity and inclusion? Comments from you all? I'm going to hand it over and see if somebody else will break the clicker.
All right, so I'm here to talk about standard 3, the planning process. How many of you guys are in fully functioning treatment courts right now? And how many of you are in the planning process where you're trying to get your court off the ground? Nice. How many of you guys, this has nothing to do with the standard, this is your first time being at a WATCP conference? All right. So planning is super important for your treatment court. There's several tools online that you can find if you're trying to get your treatment court off the ground. Just let me know if you'd like access to some of those tools. I have them saved that I can send out to you. But really what the planning process is getting your advisory board together. And your advisory board, generally speaking, is a CJCC, your Criminal Justice Coordinating Council, which is usually a subcommittee of your county board. But what this group does and what they can really help you with is finding resources in your community. You want to have people on your CJCC that are kind of the power players in the county, people that can make decisions, people that can get you financial help with your treatment court. They can do a lot of community mapping. They can help you with budgets. They can help you review forms. And a lot of what they can help you with also is reviewing your data and making sure that your program is doing what you intend for it to do. You're also going to want to have a pretty comprehensive policy and procedure manual. These are suggestions for all the things that should be included in your manual. There might also be some other sections that you guys add just because of something unique to your community, some other unique programs that you might have access to, things like that. You want to have all of these sections in your policy and procedure manual. So if something happens to you, heaven forbid your coordinator quits, there's team turnover, somebody can pick up that manual and start that program just like they were involved the entire time. That's how specific you want your policies to be. I'm not going to go through any of these. If you have questions about what any of these are, feel free to come up to us and ask. Otherwise, this presentation will be about 6 hours long. So I think honestly, that's it for standard 3. I chose the short ones. I'm smart. Oh, sorry. Any questions on the planning process? Any questions online? All right. Yes. Oh, wait, hold on.
It's really just a general question. Are we going to get a copy of this? You're going through things pretty quick sometimes.
Yeah, you should have had it, actually. Yep. Jess will tell us. Jess knows everything.
So on your welcome email, if you scroll down to where it says conference materials, it's a light blue button. You will have, it's so weird hearing this in my, okay. Just open that and it'll take you to the website where all of this stuff lives. We have the whole week's worth of materials up on the website. You might have to register and create an account there, but you should be able to access it. And that goes for anybody at home as well. We have about 80 people online with us right now.
You can also go to my website, which is the Wisconsin Courts website, find the treatment court page. And this, a previous standards training is actually there recorded. So if you have any questions that pop up, 6 weeks from now, you can always go back to that resource too.
There's a lot to manage. I'm going to apologize ahead of time. I am a very fast speaker, and when I have all of these eyes on me, I can guarantee I'm going to speak even faster. But I do want to welcome everybody. Standard 4 is about the team, the treatment court team, which is comprised of a dedicated group of individuals and professionals from all kinds of different disciplines. The team is responsible for managing and overseeing not only treatment services, but also the supervision services. As you can see, there's quite a few folks on the team, and we're going to dig a little deeper in each one of those different roles. But we have the judge, the coordinator, prosecution, defense counsel, community supervision, which in the state of Wisconsin is generally the Department of Corrections staff, the treatment representative, law enforcement, and ancillary services. And I'm going to just stick with ancillary services for just a second because we don't dig deep on that one later on in this presentation. But ancillary services really means persons who might be coming from workforce resource that are on the team, or somebody from a domestic abuse shelter. So we do want members of those services on the team because their input is valuable. But we aren't going to dig too much more deeply into that. But please let me know if you have any other questions about that specific role. For the judge is really the lead of the treatment court and the team. What I will say from my experience with the judge is the role of the treatment court judge is traditionally a little different than the traditional model because it's pretty interactive. And participants might not be used to that. Usually their attorney is the one who's doing the majority of the talking. Well, in the treatment court, you have the participant doing the majority of the talking with the judge, which can be something that needs to be discussed and talked about with the participant. But the judge is responsible for, assuring constitutional guarantees of due process. Judge also has a disproportionate impact on success of the participants. So that's something to keep in mind. That judicial interaction is very, very important. We want the judge to really be the person who provides and gives out, I guess, all of the sanctions and incentives. We want that where we recommend that it be at least the 4-to-1 ratio. Team members, the judge may need your help in identifying some of those rewardable behaviors. So please offer feedback to your judge. We want you to say every possible positive thing that you can say to participants. The coordinator. I used to be a coordinator. So this is the well-oiled machine. We got to keep it running, right? This role, this person is doing a lot of tasks. They're managing many different activities within the court. They're the ones who are traditionally keeping the program moving forward. Some core competencies, they're really responsible for case flow management, not only referral, but to disposition of the treatment court, to case management activities a lot of times, but also data collection and grant reporting, which everybody loves grant reporting. They're also responsible for strategic planning, building relationships, and documenting a lot of activities within the court. Heather kind of referenced that with the policy and procedure manual. They're responsible for updating that, and we make changes to our programs all the time. So a lot of times the coordinator has to go back and update the policy and procedure manual. They also really are responsible for orientating new team members. This is a really important task. A lot of times we forget all the acronyms that we use or forget some of the nuances of the treatment court. So making sure that the new team members are orientated is very important. The role of the case manager, a lot of times in a lot of programs, the case manager is the same person as the coordinator. The coordinator or the case manager, excuse me, is really responsible for case planning, and we'll talk a lot more about case planning in a different standard. They're also very much involved with crisis management, crisis intervention, crisis intervention, crisis intervention. And Kim referenced responsivity needs. The case manager is really working hard, especially in phase 1 and 2, to help address responsivity issues. This can be very time consuming. So you may hear from your case manager that they spent 15 hours on one client. Sometimes that happens. So keeping in mind, if your case managers aren't responding as fastly as or quickly as you would like, maybe they're in the midst of a crisis intervention. So a lot of times that case manager, especially in phase 1 and 2, is the support system for that participant. They still need to build their support system. So the role of the prosecutor. So the prosecutor's role is the leadership is very important. They advocate for victims' rights. They advocate for public safety. They also help hold participants accountable, as do all the other team members. Without the support of the prosecutor, it's pretty difficult to adhere to best practice standards. One thing I would like to mention is that in some programs, there's more of a gatekeeper concept with the prosecution role. We actually would recommend that there be more of a consensus. If there's more of a consensus, there's a higher likelihood that there is going to be equitable and fair access to the programs. And Kim kind of mentioned that. So please keeping that in mind as you're kind of working with your teams. When we have a prosecutor at our team meetings, we have 2 times greater savings. So this is another reason why it's really important to have that team member at the table. Public defender or defense counsel, depending on your program, their involvement may differ if you're a pre-trial or pre-conviction versus post-conviction. Majority of courts in Wisconsin are post-conviction, but the public defender defense counsel really ensures that participants have their constitutional rights are protected. They serve on the team, but they cannot represent individual participants at a sanction hearing or termination hearing. They should be different persons. It's also very helpful to the defense counsel if there's a matrix for behavior response, so that if there's a sanction, you can follow that behavior matrix to impose the sanction. Participants are entitled to defense representation when they face a jail sanction or termination. When we have the public defender attending team meetings, we had 8 times greater savings. Again, another reason to have that public defender or defense counsel to the team. The treatment representative, Kim. The treatment representative could be an addiction counselor, could be a social worker, it could be a psychologist, it could be a clinical case manager. The treatment provider is responsible for kind of collecting information from other treatment providers and providing that information to the treatment court team. Sometimes the treatment provider might be the person that's actually providing direct practice. Other times it's somebody from the agency, but that person is responsible for kind of collecting that data or that information and sharing it with the team. We also really rely on our clinicians to teach us and explain best practice standards as it relates to treatment curriculums and things like that. So being prepared to educate your team, or maybe even offering, quarterly meet and greets where you talk about some type of new program that you're rolling out in your agency. That might be a good choice. When we have a treatment court representative at the court hearing, not necessarily a staffing, but both, we have a 9 times greater cost savings. Role of the law enforcement representative. Typically it's a police officer, a sheriff, deputy sheriff, highway patroller, jail official. They are really the eyes and the ears. They hear things that we don't hear. So it's great to have their input. They also will a lot of times help with home visits. I know that when I was doing case management, if I said I was going to go do a home visit, the law enforcement rep on my team would be like, you ain't going alone. I'm coming with you. And I really appreciated that because they protected. They made, they know more than I do. Maybe they knew that there were a lot of people that were hanging out at that house that it wasn't going to be safe for me to go into that home. They also a lot of times help with urine collection or drug testing. They really do serve as kind of the liaison between the other correctional officers or law enforcement officers. So we really want that person to kind of educate other law enforcement officials about the treatment court model. And hopefully it's a positive voice about what we're doing in the treatment courts. When we have law enforcement, again, we have greater cost savings. Role of the DOC or community supervisor. So the DOC agent a lot of times works very closely with the case manager when they're doing case planning, when they're performing drug and alcohol testing. They too conduct home visits, employment visits. They also help enforce curfew and travel restrictions. They also do a lot of our carry guides and our BITs, brief interventions. We really need them to help with improving the problem solving skills and to help kind of address some of the criminal thinking patterns. Lots of carry guides and lots of BITs. How many DOC agents do we have in the room? Yeah, you guys are good at that. It's really impressive the amount of work that you've all done in that area. So that staff meeting prior to court, that is a required component of the treatment court model. At those pre-staffings, we talk about participant status updates. What are they doing? We're talking about what services they're working on and completing in regard to their case plan. It also really, like I referenced before, helps the judge prepare for the status hearing. So providing the judge with some possible questions that they might be able to ask that participant, providing the judge with ideas on rewardable behaviors. Consistent attendance by all team members significantly increases the outcomes. So please keep that in mind as well. So staffings are closed. We generally don't want all kinds of folks coming in and hearing some of that protected information. So please keep that in mind. Participants sometimes do join the team staffing. Maybe you want to talk with the participant individually about some concerns that you have with, especially as it relates to clinically sensitive information. You may not want to talk about it in a court hearing. There are lots of courts that do that. Please remember that the team is serving as the expert of witnesses for the judge. So please speak up in your team meetings and your staffings. Provide relevant information and insights. It's greatly encouraged and highly recommended. Consistent communication is also very, very important. We want to avoid triangulation or staff splitting. We also don't want participants to have to tell their story over and over and over again. So keeping that in mind, that it's important to kind of share information between your team members. We don't want participants to fall through the cracks. So let's say the DOC agent knows something, it's important for that agent to share that information so the case manager can maybe follow up with whatever happened at the probation agent meeting. Please also remember that releases of information are very important. There should be releases in place. We don't want information to be shared without those releases in place. I told you I talked fast, right? Any questions from anybody?
Just a quick question on team roles. So recently, our team has been pretty balanced, but recently our sheriff's department has taken a bigger interest in our treatment court. And so already we had a representative from the jail, the police department, and the sheriff's office on our team. Now our drug task force wants to be involved. How heavy can we get in without, I mean, I want to keep our team balanced, but I also want to involve those people in our team.
Yes, I mean, balancing the treatment team is very important. One way to kind of work around that, then you all definitely jump in, is to really make sure that you have clearly defined eligibility criteria and clearly defined policies and procedures about persons that may be contested for coming into the treatment court. If that's in your program, that's going to help balance it out. Though, yeah, when it's probably going to increase the time it takes for staffing because there's more input. So yeah, I would encourage you to just do the clearly defined eligibility criteria and policies. And we can definitely offer more support individually to your program if you need any support in that way. You guys are making me run.
I think that we need to look at the HIPAA. We need to add 42 CFR Part 2 for substance use disorders because there's a lot of information that we're not obligated to share. So, I mean, that's something that those that aren't in the treatment aspect of treatment court need to know about.
Yes, that is a very good point.
We're going to talk more about that when I get to come back up here and talk about treatment, but you're absolutely right. There is a need for an understanding from our fellow team members sometimes that law, our license, our job, our relationship with the participants we are working on a treatment plan gets in the way sometimes. And we need some mutual understanding sometimes. And sometimes no is a complete answer.
The question online is to verify the treatment representative may or may not be a treatment provider for these clients.
So St. Croix County uses what we call a liaison system where the treatment provider who serves the treatment court team is a licensed treatment provider, but does not provide treatment to treatment court participants. I do, and I don't go to team meetings or team staffings. Instead, I work with our liaison, who's a colleague in the clinic of mine, to make sure that she has the information that she needs to be shared in the team meetings. I probably provide her way more information than what she needs, but I don't want to leave her hanging in a staffing either where somebody says, what about this? So she, as our liaison, has somewhat of a really difficult role. She has to figure out what does treatment court need to know and why, and what should stay in treatment so that that rapport and all of those pieces can continue. So yes, any treatment provider serving a treatment court should be a licensed, experienced practitioner, and preferably an experienced practitioner working with justice-involved individuals. Again, I'll get on this soapbox again when we get to the treatment standard, but they don't have to be the direct provider to your participants. Lots of courts do it differently. I'm not saying that a direct provider can't be on a team and maintain rapport and provide effective treatment. It can be done. It's just another layer. So I think that when Marcia mentioned that sort of dual role, or a person who isn't necessarily the provider of the treatment service should still be a treatment provider. Does that clarify? I know that question came online, but does that clarify some things in the room? Wonderful. I'm going to walk over here, but I'm going to give this back to Marcia, believe it or not.
When you talk about the team members, the participants expect some level of confidentiality of what is shared in those team meetings. But at the same time, you have law enforcement sitting in as part of the team. And law enforcement is always interested in seeing what is being said and whether or not that information can be used. So the question back to you is, what limits then does that law enforcement officer have sitting on the team and not taking that information out and using it for prosecution?
Oh, no, again, it's a great question. And that's why I think trainings like this are extremely important, knowing and understanding everybody's role at the table, right? There are more than just your law enforcement officer who are sitting at your table concerned about public safety. That's their job. And public safety is an important piece of treatment court. And that's where I think having discussions with your team, whether they're heated or not, about what your role is, what information you're supposed to provide, what information may not be provided, and reasons why, to find that understanding among your team members is the only way that you're going to get around some of this. There are a ton of great resources out there that we will show you, not necessarily the resource itself, but a list of where you can find them that talk about roles, limitations of roles, relationships between roles. But if you have a law enforcement provider that's coming to the table simply for gathering information to share with all their other law enforcement participants, I would suggest a really long sit-down conversation with that provider. What's their interest with that provider? I'm in treatment world. With that law enforcement officer about what their interest in being on the team is. If they were told they have to be there, that's another layer you got to work through, right? But if they're there because they want to be there and they're there to help each individual participant through that program, it shifts. If it can be done within public safety and their duties as a law enforcement officer. Same with your prosecutor. Same with your defense attorney. Heather reminded me as I walked over here that there's a lot of limitations on confidentiality between defense attorneys that may have information that are coming to your team meetings. So it's more, I think, about your team dynamic than it is about individual role, and an understanding of what is the mission and the goal of our program when we come together. But it's a great question, and I think it's a great barrier that many of us face. Another question online.
For a participant facing a sanction, are they entitled to adversary counsel apart from the public defender on the treatment court?
I know the answer, but it's not my turn.
Yes, treatment court participants are entitled to adversarial representation whenever they're facing a sanction. The defense attorney on the team does not represent the participant. More likely than not, the public defender's office is going to have to find an attorney to cover due to conflict of interest and things like that. But if there's an attorney at the public defender's office that can cover it, they can, and the person qualifies. But they are entitled to representation.
My question is, if you have a judge who is not very into treatment court or doesn't even support the idea of treatment court, he's the one who makes all the decisions, really. What do you do?
Well, Mike's definitely going to talk more about this later, but data drives decisions. So what I would encourage, and I'm going to come up here to allow the other cohorts to respond, but data drives those decisions. So if you can, compile data and show that to the CJCC or whatever advisory board you have and the judge, that might make a difference in that perception or how that judge may or may not feel.
Educate, educate, educate. Talk to your judge about why treatment courts work. Have them come to our conference. Have them come to any other trainings that we put on. There's tons of judicial trainings that are offered through national providers. I send a lot of that information out from my office. You can also have us come out and do individualized trainings for your teams if that's an issue. So just contact us and we're happy to help you through that. Yes. Oh, and we also are having, if anybody is interested, a treatment court specific judicial training. It's usually held in February. This year it's going to be held in August because of COVID, but that information will come out too. But every year there is a treatment court specific judicial training offered by the director's office. Any other questions?
Sorry, we obviously all live in separate places, so we can only plan virtually as much as we can. One thing about this training that we aren't able to do in this environment or virtual environment is normally when we do this training, a part of the afternoon or a part of the break is actually where you can meet with other people in your same role. So the coordinators and case managers would go to one room, the judges would go to another, so on and so on and so on. We can't do that today. You'd be here forever. We don't have enough space today, but we do have two ways that you can access this information. First, WATCP is going to be continuing our webinar series where we will do webinar web connects, I think we're calling them, where we will offer a opportunity to connect virtually by your role. So coordinator, prosecutor, defense, judge, and then we will do another by your court type. So we will host a drug court session. We will host an OWI court session where you can do this networking virtually, of course, so we can access as many of you as possible. So look forward to that coming in the future. Also, I would highly encourage if you can get on WATCP's website, there is a board of directors, and our board of directors is made up of representatives of every discipline that serves a treatment court. So you can get right on there. You'll find our pictures. You'll find who's your treatment representative, who's your coordinator representative, who's your judge representatives. Their email and contact information is right there. So if you have a question specifically for a judge, if you have a question for a defense attorney, you can find us, you can click email and it will send right to us. I promise you, if we don't know the answer, our board is very committed. We will find the answer and we will get back to you. And apparently we're going to break out by disciplines on Friday as well. So you'll have an opportunity to start those conversations if you're still with us here on Friday by your discipline specific breakout. Perfect.
Okay, it's my turn. Most important question, the clicker right here. The last couple of questions kind of anticipated my my standard that I'll be covering. That's the judicial role and interaction. And as the questions note, being a judge in a drug treatment court setting is a different animal than a traditional judge in a criminal court setting. So we'll cover that here in the next few minutes. So really standard 5 is about the judicial role. The effective treatment court judge, he or she acts as a leader, a communicator, educator, a collaborator, helps with the building of the institution of the program itself. A judge interacts frequently and respectfully with participants and gives due consideration to the input of other team members. So it's really a different dynamic than what we're used to through our own experiences or what we see on television, for example. So it does work, yeah. So 1 for 1. So really, what are we talking about here? The judge is leader of the treatment court team. We're really talking about a relationship between that judge and each participant that continues. It starts right at the level, at the stage where the participant has just been admitted, and it continues throughout the months or even years as the participant works through the program. And the message we hope that's being imparted through this whole process is that a participant is thinking to themselves, someone in the authority really cares about me, really believes I can succeed. We know how often that message doesn't get conveyed and how people perceive themselves as anything but successful. So this is really a kind of a paradigm shift if done correctly. So that's an important thing to think about as we move forward. We've mentioned a lot of research. Oh, see, if I, whoa, we did. If we walk and chew gum at the same time, the old joke. I'll set it down. There we go. We're going to throw some research at you, as you already know, cite some studies. And one study is through Carrie found that treatment courts are much more effective for those programs where the judge is actually in place for at least 2 years, 2 consecutive years. If you've got shifting every 6 months, every year, there's so much learning that goes into this, getting comfortable that the program loses a lot of traction. So we really encourage rotations that are set for at least 2 years. Not usually a problem in counties where there's one judge. We were kidding the other day with Heather that are there any studies that show a margin, diminishing margin of return, so to speak, where if you're more than 4 or 6 years, it gets less effective, but we're not aware of any such studies. But that does lead to the idea, the concept of having a backup judge who's trained, who's knowledgeable about treatment court programs, who can step in when the first judge is on vacation or caught up with a scheduling conflict. So, and oftentimes we find in less populated counties, it might be a neighboring judge or a retired judge who serves that backup role. So that's an important concept as well. But the idea is that it's the same judge who presides throughout all the various stages that a participant is working through in the program. The research, the studies have shown that judges that stay at least 2 years on a program results in 3 times greater cost savings in the program. And we mentioned cost savings because one of the big goals of treatment court programs is to reduce costs that counties face through incarceration costs. So there's a lot of savings that are achieved just from keeping participants out of jail, not only in the current situation, but in the future, because they're not recidivizing and repeating themselves offenses here. So we'll move on. Length of court interactions. So, and what that means is a court, we have weekly, bi-weekly court sessions where program participants appear in court in front of the judge, for kind of a status review of where they're at with the program, with their behavior. And in programs where the judge will spend at least 3 minutes a piece on each participant, on each matter, there's a much greater reduction in recidivism. It's been found that that's the case. So it's really important, especially in those programs where you have a lot of participants, that there's still that individualized attention that a judge can devote to the participants. And that's really important. And then it also leads to the type of questions that are being asked of the participant. And we have a few listed on the slide here. Others that we've witnessed that I know that are considered to be very good are just open-ended questions like, how did your week go? What kind of concerns did you face over the past week? And follow up on that line of questioning. And as a person works through the program, is achieving some success, experiencing success. And again, for a lot of folks, they haven't had a lot of success in their lives. When a judge is asking a participant, where do you see yourself, at the end of this program? What do you see yourself in terms of employment, in terms of being a father, being a brother, member of the community? That really gives a participant an opportunity to weigh in on that. So these are all really important questions. And we've talked in other settings about the importance of motivational interviewing as a model, and getting team members training and motivational interviewing. And that includes judges, so that line of questioning becomes ingrained, because that's not what you're hearing judges ask criminal defendants typically. So also trauma-informed approach is a concept we're going to hear over and over as well. In a traditional court setting, criminal court, it's a very adversarial. There's incarceration, punishment mentality, and that's the role of a criminal court system with public safety at the forefront here. There's order. There's very much an authoritarian ambiance in the courtroom. The new approach, so to speak, with the drug treatment court, much more collaborative, a much more supportive ambiance, much more of a team-based approach, really talking about healing, the respectful demeanor, the whole idea of recovery support is playing out, and that includes the courtroom. It's easy to think when you see this that, well, this is kind of like a 12-step group meeting. This is a social worker approach, but there's definitely an accountability mechanism that's built into this. It's not that people can mess up in terms of compliance and not be called to task on it. That's still built in, or should be built into it, so that that they are accountable and have consequences for their non-compliances as well. So, but it's very important that we have build into this a much more collaborative demeanor. So the judicial demeanor under our treatment court model features supportive comments, the importance of staying committed to treatment, getting through the treatment to achieve your sobriety and other program requirements, community services, things like that, and express optimism as much as possible. Again, a lot of participants aren't used to hearing optimism. It's a real boost for them to be exposed to that. The trauma-informed approaches are important. Using motivational enhancements. Those of you who are part of treatment court programs know about the use of incentives and sanctions. We'll be talking more about that in a little bit here, but that's a big part of it, the carrot and stick, so to speak, that manifests itself through the use of incentives, like gift cards, things that people, that participants can win and earn on a weekly basis. And avoiding as much as possible, avoiding confrontation, that kind of is baked into the criminal justice system otherwise. And then there's an element of procedural fairness that we see in our court and judicial system here. The idea that the judge really understands the participant's case. They know the participant by name. Again, they're encouraging that person directly, individually. And really, maybe the key point here is letting the participant tell their story. And that isn't just, what is their excuse for missing a meeting or for failing a drug test? What are the circumstances behind it? And we've all gotten out to enough site visits now where we've seen judges who, on the one hand, they're disappointed that a person may have come up negative on a test. But when the person is very upfront about it and explains, what the circumstance was in their life that may have triggered it, and are very proactive about it and honest about it, the judges are by and large, are very encouraged by that, encourage the honesty, encourage the understanding, that people make mistakes. Nobody bats 1,000 when they're recovering. And so they're even in a kind of a negative situation, the judge is trying to take a more optimistic, favorable stance on what occurred. So, and again, this kind of leads to these bullets as well. Minimize the shaming, name calling, labeling. We don't, research has been real clear over the years in a lot of settings that shaming does not work long-term. Also, this, again, a unique setting because the team members, the treatment team members are part of the team, are the expert witnesses. They provide a lot of advice and support to the judge when they make those decisions. And the decisions are often made even prior to the court when the team meets for their staffing and discuss the various participants and what's happened over the last week. And the judges are very deferential to what the team advises. They really are listening to all different perspectives, and the teams aren't always in lockstep agreement. There can be some disagreement, healthy discussion about, whether a sanction should be employed, what type of a sanction when a person does slip up. But that's important feature here to have for a judge who's really invested in this program to really rely on their team. So again, letting participants have their day in court, so to speak, and tell their story, their explanation, and it might be a good explanation. It might not be a good explanation. It certainly can be a teaching moment at that time. And then judges themselves becoming more knowledgeable on the science and the topics behind addiction, alcoholism, recovery concepts, brain disorders. It's just very important. And I think you find that judges who've been in the program, for a year, 2 years, automatically through curiosity, talking with their team members, become much more knowledgeable in that area. And as I said before, relying on your treatment providers to help make decisions, treatment-based decisions, because they're really the ones that are the experts in that area. So these are all important things to think about. Again, we're not talking about a punishment or retribution model like some of us learned back in college or law school or whatever about the criminal justice system, where you did have a rehabilitation motive, but you also had a punishment and a retribution model. This is not what that is about. So it's also important for the judge, for court officials to give some attention to the setup of the courtroom, the ambience of the courtroom. How can we make it less intimidating, less stark? Again, remember the criminal court traditionally is a very stark, oftentimes a very stark setting where who the judge is and where the DA is. And it can be a very intimidating setup. Here we're really talking about access to the judge by the participant. They get to appear right, real close to the judge, have the judge's attention. Somebody earlier asked about lawyers and if they can be represented, and the answer is yes, certainly they can, and a lawyer can be present next to them. We'll talk a little more about that in the next standard here. But there's respect through level of eye contact back and forth between the judge and the participants and the other team members. The other participants might be in the public gallery. They might even be sitting in the jury box. There's going to be different setups in different courtrooms, of course, but the idea is to make all the participants feel like they're part of a discussion, part of a real helpful discussion, and not be shunned or shamed and labeled by being, put in one spot for everybody to look at. The processing of cases. We've seen a few courts that have kind of dispensed with naming the case number. They just name the participant. They don't say State versus John Jones. They just say, okay, John Jones, it's your turn to come up before the bench and let's talk about how the week went and go on from there. So it's really a much more informal type of an approach between the judge and the participant. And the judge is addressing the gallery. The judges, there might be 10 or 15 participants on that particular day. Much of this constitutes a teaching moment. So the judge is saying something, making statements directly to the participant, but the judge is also speaking to the others so that they understand what message the judge is really trying to convey. And oftentimes there may be a theme of the day that the judge is asking everyone, each person, what is financially have they learned about financial management? Or, some of you are old Boy Scouts or have kids in Boy Scouts, what was your good turn today or this week? What did you do for your community? So there's a lot of that, along with the physical contact, any proximity that's closer, and then arranged seating as well. As I said before, there's going to be non-compliances. There's going to be some failures. We all know that. How do we handle when a person slips up? This is where a judge can really, really shine. This is where language really matters. What instead of lecturing the person on their behavior, the judge might simply ask, give some thought. How do you think this behavior has or could hurt you or your family? Let's talk. Let's think back to what happened, and let's think about what you could have done and how that would have looked, how that might have played out instead of what choice you did make. And being reinforcing. I really think you can turn this around. And when you come back next week, I'm excited to hear about how well you did this past week. I really like how what you did this past week. I really appreciated your honesty and why that's really helpful for you in many different settings. And over and over and over, the courts that are most successful, the message that you hear is, I'm really proud of you. We're really proud of you here, the team. Keep up the great work. It's really a lot of encouragement that's important. So, and even terms like when talking about blood tests, if they came back positive or negative, that's much more preferable to clean or dirty. That conveys a message, especially if you're dirty by failing a test. And then and we all know this, not referring to somebody with an addiction as an addict, but a person may have a substance use disorder, may have a challenge, may have a barrier that they're trying to address. So very important. And now my thing doesn't want to work again, so we'll go to the next slide. We really talked before about the class. The court is a classroom. There's a lot of educational moments in drug treatment court. So, but before, there's still an accountability mechanism built into this. What's really neat about the best drug treatment court programs, though, and how they operate most effectively is when the accountability, when the sanction is tailored to meet the needs of the person, the individual, based on the level of behavior, based on how frequently it's been taking place. And the team is there to help the judge figure out what that sanction should look like. So there's plenty of accountability. We've heard from some of the programs, there's some defendants who opt to serve their time in jail because they think it's easier to serve their 60 days or pay their fine instead of work the program, because there's a lot of requirements. There's a lot of expectations built on them. So we can go to the next slide. Thank you. So really, there's a lot here. And as we say, for most of these standards, there's additional resources available. You can access them through through Heather's office, the State Director of Courts office. The Judicial Bench Book has a lot, and a bench card has a lot of information on the kind of questions that judges might ask participants. Of course, the conferences, this conference, the National Adult Drug Court Practitioner Conference, different judicial conferences and seminars. Kimberly mentioned one just a little while ago, and there's many different webinars that are available. So are there questions? Any follow-up questions on Standard 5? All right, number 6, Standard 6. Yeah. Number 6, yeah, okay, number 6 will take less time, hopefully, than 5. I realize it took a little longer. I get long-winded sometimes. I apologize for that. But we'll talk about kind of a related standard, and that is balancing the non-adversarial, the collaborative approach of drug treatment courts with due process concerns. I get the first thing we really want to. It does. Okay. All right. Okay. It's easy to fall into the thought process that drug treatment court is sort of a, is out here, is not really court, and nothing could be further than the truth. It is court, and with that, there's due process requirements and rights that have to be upheld for our participants. Those, we can't lose sight on that. And that's where that has to be codified, that has to be recognized in our policies and procedures. And the handbooks that are developed for each participant, so they're knowledgeable about their rights. So that comes up in all these different stages of treatment court, which includes admissions, the sanctions and incentives that they can earn or sustain, as well as phase advancement. There's usually 5 phases in most programs. So there's criteria set aside defining when each participant can advance up to 2, 3, 4, and 5, as well as the treatment that they have access to, the right to treatment, the requirements for graduation. And then of course, the last bullet, and it's an unfortunate reality, we have terminations, we have expulsions for failures in the program, or, very long-term sustained serious violations that can only be dealt with through terminations. These all have to be spelled out in your policies and procedures. All right. So it's really important that participants right out of the gate, before they're admitted into the program, are made aware of what their obligations and rights are. So this is going to be reflected through the contracts that they're going to be signing on what they're obligating themselves for, any waivers that they are signing in terms of information sharing and other type of waivers, all the policies and procedures of the program, what rights and responsibilities that they have to be reviewed by staff with potential participants. And then when the participant agrees to join the program, the judge at the hearing will have a dialogue to ensure that the participant understands this. And it's really key that a program allows a participant to be heard at every stage of the proceedings. And that's kind of a common mantra that you're going to hear over and over, that they have the opportunity to challenge violation allegations against them, to present evidence, and also in terms of treatment and support groups, that they have the right to join their own. We all know that from our state law, the right to self-plan, have a say, but also to engage in non-deity-based treatment and support programs. As I said before, treatment court is still court. It is still a court. And everybody in a courtroom still has to honor that. But part of that means that the participants do have the right to counsel, as was asked before, at all stages of the proceeding. And just again, to clarify, teams typically should have a defense counsel, have a public defender representing the team to bring in that viewpoint throughout the various deliberations. But that person is not a participant's personal attorney. That participant will be represented by someone else from the bench, another public defender, and there may be some conflict of interest issues that have to be rectified there, but we want to just clarify that. Also, participants have to make a knowing waiver of any judicial conflict of interest or ex parte communication that before they enter the treatment court. Now we got the bullets coming in one at a time here. So because it is a court, there has to be a record kept of the proceedings, and that's under State Supreme Court Rules 71. So even though it's a treatment court, even though it's more informal, there's a lot more give and take, there's still a court reporter typically present who's recording the proceedings. Part of due process involves drug testing and the rights associated with that, and that includes a clear chain of custody that's defined for the drug samples that are kept. And that also means providing an opportunity for the participant to request a subsequent and additional test to confirm whether the initial results are the same or not. The team, the treatment court team, the participant, they all understand that the due process rights also are separate from what due process rights exist when a participant is under supervision with Department of Corrections when they're probation and parole. So those are two separate things. And of course, we're talking about teams of 8, 9, 10 members from different perspectives, different professions, and each profession has different ethical obligations or legal obligations that they have to fulfill in their role. So that has to all be kept in mind as well. And really, the last point here, it's really important, and I think you'll find that the courts that hum along the most smoothly are those where team members really understand and respect each other and where they're coming from, what their perspectives are, their responsibilities are, and what the boundaries are. So that way you get the best kind of feedback that doesn't overlap or result in a lot of conflict. All right, do we have any questions on standard 6? Why don't we take a few minutes? Okay, I'm going to hand it over to Heather.
All right, so we're going to give you a pretty substantial break here. We're going to give you about a half hour. So if everybody could come back at 2:45, there is going to be out in the hallway here for those of you in person, sorry, online, salted caramel brownies out in this hall. It's going to be there at about 2:30. So 2:45. We'll address the question that came in online when we come back. Right outside this door here, there's a little desk right there.
Okay.
And Jody should be there and she can help you.
Not sure I understand this point. Objective eligibility criteria. Subjective factors would be, I suppose, if a participant has been on the program, has been in the criminal justice system, other members of the family have been in the criminal justice system and haven't done well or are not liked. There may be a sort of a bias, built-in bias against dealing with a particular person because of an unpleasant episode in the past. We really want to stay away from that, coloring the team's judgment, the judge's judgment on whether to accept a person into the program. Early identification, referral as quickly as possible, using validated assessment tools, which we'll be getting into here in a couple of moments. And again, the crime itself, the offense itself, there has to be a nexus with a substance use disorder. That has to connect with the crime itself. So that's probably, I think that's all we've got at the present time. And this thing fell asleep again. Are there any questions? Any follow-up questions? Yes. I'll hand the microphone to you.
I work in the tribal courts for the Healing to Wellness programs. And considering that TAD has a restriction for violent offenders to re-enter the program, the federal funded programs for Healing to Wellness courts, they also have a restriction against violent offenders and sex offenders. Is there such a restriction at the state level for the sex offender?
That's a good question, and I'm not sure. I'm not aware that there is. I don't know if either of you have experienced that or been confronted with that question. I'll hand it over to Kimberly here.
And again, I am also not an attorney, but we have at the state level, we have asked past folks in Mike and Marcia's position, and there was a position that sex offenses should be considered violent in nature. However, the TAD statute, when under a legal review, talks about intent to harm, bodily harm, different components that some sex offenses may not fall under, like a possession of pornography that didn't necessarily have the details where a victim was put in harm's way, if I can say it that way. So it gets really sticky and really tricky because the statute is worded with those two parents of very specific criteria on how it can be applied. So one recommendation I would make is that you have your judge or an attorney who's well versed in that statute gather as much information as possible, because sometimes those of us who are screening these don't even get that information. And have them specifically run through, does it fall in parent A? No, now we're looking at B. And I think the difference is current crimes or past crimes. But anyhow, have them issue a written decision on whether or not they're excluded based on that criteria or brought in by that criteria, or make a decision as a team to have a blank exclusionary criteria about sex offenses, but make sure it's published and make sure that people are getting advance notice of that. And Heather's going to clarify everything I just said.
Just for the people online, if you have a question, you have to submit it through the Q&A function. We can't put you to talk with your raised hand feature, so you have to put it through the Q&A.
Let me just cite the statute that we're actually referring to, the TAD statute, which excludes violent offenders. It's section 65.95 sub 1 sub BG. And then within that, there's there's two paragraphs. One paragraph defines persons who have been previously convicted with a felony. And then the second paragraph gets into a further description of people who are charged with an offense where there's harm, where there's intent to commit harm. And again, I don't have that language to put up here, but if anybody has questions about that, feel free to come up and see me later during our next break or over the course of the next 3 days. I'll be here. Any other questions? Yeah, that one too. The question is, what is the statutory provision that suggests that a program can only serve those persons who commit the offense or are sentenced and convicted within the county of the program itself? And that's 165.95 sub 3, paragraph 3. So, and likewise, if you have any follow-up questions on that, I'm happy to talk with you and discuss that with you during a break. Okay, hearing no more questions, we'll move on to the next standard, standard 9.
I'm going to break from script for a minute if I can. I'm surprised Heather's eyes didn't just go like this. I wanted to give an example of how you can use these standards beyond just knowing what they are, but how do you use them to make decisions? And I'm going to use an example from St. Croix. Sorry, guys. Most of St. Croix has changed teams, including myself. And I'm not sure we've totally resolved this issue, but I'm going to bring up one way that we attempted to use the standards to take a look at our eligibility criteria in terms of drug dealing related offenses. And actually, I'm going to go all the way back to a conversation that started between Marsha and I a year ago or better, where she had emailed and said, how is this being handled in St. Croix? And we started this email conversation and it kind of went along, well, we could do it this way, but as long as it's objective, meaning we can apply the same criteria to every applicant, you could probably add that as a disqualification or an eligibility criteria to get in. And I think Eau Claire went all the way through the process and actually now has an objective measurable process on how you deal with drug dealing offenses to get into the programs in Eau Claire. So they got a little further than where things got with St. Croix when I left. But the process that we used in St. Croix then to take a look at this and actually use the standards and break it down is I put together a Word document that had the Wisconsin standard language, the national standard language. So that's what our teammates were looking at first. Here's the standards that apply to this area. And then I took as much data as I could from the court and said, here are all the people that we took into the court that may have been disqualified if we used a drug dealing at, I think we borrowed Eau Claire's. So we took Eau Claire's and we said, if we were to apply this to our program, here's all of the people that would not have made it into the program that already have. Here's the graduation versus termination rates when those folks were in the program. Were they having an effect on the other people? And we went through probably 10 pages worth of data, and we had some great discussion, and I think they may still be working on this up there in terms of, are they going to create an objective based on the standards and based on our program data that says this is what will qualify or disqualify? I would assume then that when they make that decision, they publish that. They put it in their policy and procedure manual. They get it out to all attorneys who that may impact, because that advance notice piece is a piece of it as well. But that's how you take this stuff and make it work in action, rather than just coming to a training and saying, yep, sounds good, looks good, I get it. This is that next step of, when do we use it? How do we introduce it? How do we make sense of it? And I will tell you, I was looking when Mike mentioned the sex offenses, I pulled the national standards, and their disqualification criteria is the most vague criteria you could ever read. The direction that we get from the state, if you're TAD funded, gives us more objective, measurable exclusion criteria than you will find in any of the national standards. So that also brings great debate, because the national standards will tell you things like you'll get more cost saving the higher the risk person you take into your program. That's all they tell you. What is that risk? Is it higher because it's a sex offense? I don't know, we got to do a little more digging, right? So this is how you take these standards beyond just, yep, stamp it, got it, makes sense, and put it into action. Thank you.
Data driving decisions. Oh, I love it. Standard 9 is all about screening and initial assessment. In this standard, we're really talking about determining who's eligible and appropriate for the treatment court. And there are two different ways that we would recommend that you do that. You do a screening to determine legal eligibility, and then you do an assessment, but I think Mike referenced this, to determine clinical appropriateness. All this needs to be done with a risk need assessment that is validated. Let's talk. Oh, I need to click. You're clicking for me. Thank you. Let's talk a little bit about the evolution of risk need assessments. So this was hopefully before my time, but back in the day when we first started doing risk need assessment, we were using gut instinct. We've moved forward, and now we moved into the second generation, which we were taking into account static factors. Those are factors that don't change, like age, criminal history, age at first arrest, those types of things. Third generation, we moved into static and dynamic factors. Those include the ones I just mentioned, but also they can change. The dynamic factors can change, and that would be like community support, mental health diagnoses, things like that. We're now moving into the fourth generation of risk need assessments, where we're taking into account static, dynamic, and responsivity factors. So we're moving forward. Let's talk a little bit about, I think Mike referenced this, or we've referenced it, the risk need responsivity principle before. This is a really important concept in that we need to figure out, who are we serving, what do they need, and how do we deliver it to them? So with the risk principle, talking about eligibility criteria, high risk, high need. Need principle, really focusing on those criminogenic needs and targeting interventions based on those criminogenic needs. And then the responsivity principle is really figuring out what are the barriers that each individual participant has to fully engage in the program. We're going to dig a little deeper into the responsivity factors a little later, but we'll get to that when we get there, I guess. Developing rapport. I love developing rapport. That was one of my favorite things, working with participants and really being in the moment with them. You know, that's a skill. There are we have distractions, right? So me talking to you, not thinking about the fact that my kid's at home upset about his braces that he just got put on yesterday and how much his teeth hurt. It's very distracting, right? But building rapport, you need to be in that moment and present with the person. And so taking that into consideration, when you're doing your first screening, consider doing some possible 1 or 2, 3, maybe 4 even sessions with that participant to screen. Maybe the first session, do a meet and greet, where you kind of just get to know that person a little bit more, where you talk a little bit about orientation to the program instead of getting into the nitty gritty right away, where you're talking about, hey, tell me all of these negative things that have happened to you in your lifetime. So we encourage you to really focus on building that rapport. And I know that time isn't always on our side, but that can really take you leaps and bounds if you do take a little extra time with that screening appointment. So where is risk derived? Risk, we've already talked about, is derived kind of from those static factors, and we sometimes can take into account those dynamic factors. Little quiz for you. What 3 static factors impact the risk score more than anything else? What do you guys think? A, B, or C? Don't everybody yell it all at once. You're going to distract me if you yell it all. Oh, you guys, seriously. Sorry about that. I can see it. Why can't you guys see it? What's the barrier here? I'm sorry. So again, what are the 3 static factors that impact risk more than anything else? A, B, or C? Exactly. So A, like I said before, mental health diagnosis can change, and it in fact does. And also motivation definitely changes. I'm sure anybody that has any direct practice work has seen motivation change. There are typically folks that are pretty motivated in jail. That motivation may change when they get released and all of a sudden they're back in their environments, hanging out with their buddies and things like that. So we do recommend that you don't take motivation as an eligibility criteria, because like I said, it very much can change. So yeah, the answer is C. Sorry about that, you guys. Keeping you on your toes. What is need? Need is all about those criminogenic needs. I think, I can't remember who referenced this, but if we don't address those criminogenic needs, the person is likely to reoffend. So we need to really focus our interventions on those need areas. Why should we pay attention to all this stuff? Making sure. So like I said, professional judgment alone, we can get somewhere, but we can get even further and have better predictions if we combine professional judgment along with some of these screening and assessment tools. So that's why we're doing more work and why we're paying attention to all of this stuff. Wanted to point out that there are other offense-specific screening tools out there, and Heather and Mike and I are wonderful resources. Kim, I'm sure, also has many different options that she can share with you that are specific. So if you're looking for more resources for mental health courts or for OWI courts, please reach out to us. Even if you're in a drug court program and you're looking for more resources for mental health screening, let us know. We can share those assessments and screens with you. Clinical assessment. So the clinical assessment needs to be done by a trained licensed professional. So that's something to keep in mind. And when we're doing that clinical assessment, we're looking for the substance use diagnosis. The clinical assessment also could include the ASAM criteria to tell us what level of care that person would be best fit when they first come into the program. These results from these assessments and screens is how we develop our case plan, which we're going to get into that. I love case planning. So the assessment, I want to point out, the assessment process, boy, now I'm really far ahead, is an ongoing process. So this can change. You know, a participant may successfully complete the matrix program. So there may be a new assessment that needs to be taken into account to determine what other recovery related services they may need. So this is an ongoing process. Risk and needs matrix. We've referenced high risk, high need persons are the most likely successful candidates in a treatment court. So please target those persons. It means that we're going to provide supervision. We're going to provide access to treatment. Pro-social connection is also super important, as well as learning how to quiet stressors and live on life's terms, because we have to live on life's terms too. That's not always the easiest. Now, imagine somebody coming into our court who maybe hasn't had anybody teach them how to live life on life's terms. So we're also focusing a lot of attention on those areas. Okay, I'm gonna go to the next slide because this is a little interactive piece. So this is out of the Compass. Compass is one of the most widely used tools in Wisconsin to assess for risk. When we have this information, what does it tell us? Like, where should we put this person in terms of services? This person is a female client, very little criminal history, only 2 prior arrests. First arrest was at age 18. She's 27 years old. Yes, she's a diversion candidate. Definitely not a treatment court candidate because she is, we look at the general recidivism risk, she is low risk. So refer on. Next example. The Compass also does this handy dandy bar chart, which I always like to see the bar chart. It's very easy for me to learn when I see something like a bar chart. This helps us determine what needs the person may need. Not the needs the needs the person may need intervention for, sorry. When we're looking at this person, what services does this person need? Is it too small? Well, there's a lot of green up in here. So that means that this person does have a lot of service need, right? So this person is definitely going to need some support when it comes to substance use. This person's going to need support as it comes to antisocial cognition. It also looks like this person would probably benefit from some antisocial associate information, like how to make friends and healthy friends and what a healthy friend looks like. So relationships, this person needs help with relationships. I'd also venture to guess that this person probably has a trauma history based on the criminal personality. So definitely assess for trauma for this person. But yeah, this is a wonderful way to kind of help us determine what need areas this person may have. Look at all those circles. Any questions about screening and initial assessment? Well, you have to look at faking concerns, right? Mm-hmm. Right. And if they were willing to kind of probe a little bit, valid. That's valid because it's, oh, I'm sorry.
Compass, because in my experience, it's baloney.
How-
It's internally inconsistent.
How much should you rely on Compass is what she's asking. And yeah, you raised some valid concerns because there are so many different people who are, doing the Compass, right? And if you don't have the background information or the ability to do an NCIC report, you may not even know if they have legal charges in other states. So those are all valid.
Even if your assessor is good, it simply compares the information you put in to information put in about other people. So if the other data is incorrectly entered, it doesn't do you any good at all.
Tani, did you have another question or do you want to respond to this? All right.
Is Wisconsin using the women's specific compass with any regularity?
No, I don't think so. And I wish that they were because it's really helps determine women's risk needs. All these are valid concerns. And I mean, I think we're still a work in progress. We're in the 4th generation. So hopefully as North Point and whoever devises all of these different screening and assessment tools, they can continue to work towards improving those tools. Anybody else want to weigh in?
I would just say that no assessment tool is perfect. The assessments are kind of placing people into groups. People that generally have the needs that you have generally look like this, generally do this, but I have no idea what you're going to do tomorrow. So it just helps us focus where we need to focus, but it's not a predictor, 100% predictor of anything. But it's a lot better than us just guessing.
Tool itself, if the algorithms were made public so they could be tested, and they're not.
That's true for Compass. DOC is switching to a different tool in Compass that is making that very apparent what the algorithms are.
I'm glad that this discussion came up because the research that I've done about Compass and other assessment tools is that, you know, I represent a specific cultural participant program, and these tools don't include or consider the lack of cultural competency in the assessments. And I think the gains, the global assessment of individual needs, I think they're looking at trying to develop a cultural competency component for their testing. But, you know, it's helpful that the Compass is used by the Department of Corrections, because then when an applicant comes to the program, there's something to look at. But also, I've gone to the other part of the assessment where there is a clinical provider that can provide us with ASAM. So we don't just rely on the Compass.
Absolutely.
And you shouldn't be just relying on the Compass. But it's you should be gathering all sorts of screening information with your participants, doing mental health screenings, you know, all of that kind of stuff. All of that is valid information. Really, the Compass is to determine the criminal recidivism risk and that high risk, and that's what you're looking for out of Compass.
There are several programs that do a trauma screen, that do the TCU criminal thinking, the drug screen. Those are all ancillary screens that you are welcome to use. And though I think TCU criminal thinking they pulled off for right now because they're trying to make sure that it's equitable and culturally competent. So something to note. But yes, definitely use screening tools, a wide variety of them. And if you need any more information, let us know. Looks like Kim wants to come on over.
Just gonna get on my soapbox for a second. All of the little side conversations and things that picked up here, I go back to our equity and inclusion discussion earlier, because when we hear conversations like this about one topic or another, it suggests we probably are struggling with our feelings. Sorry, I'm now a therapist. We talk feelings, which means there may be some implicit bias and things underneath that. And I'm not trying to challenge or say who's right or who's wrong. And it probably, if I was sitting in this room as an agent, I'd probably be a little upset right now. What do you mean? This is my job. What are you challenging? Right. But these are the times when we make note. This is something I need to check in on. This is also the times where we, as folks who are going to provide training, write notes down. This is a topic that clearly has conversation going around it, right? There was lots of side conversation, lots of feelings in the room. So we'll do our best to keep this research and this discussion going. But I'd highly encourage you to make yourself a note and write in and check in on what it is about this conversation that you want to explore more.
Thanks, Kim. Any other questions? All righty, let's move on to case planning. So case planning, this is the process by which staff and the participant work together to develop and rank, identify criminogenic and responsivity needs that were derived from the risk or the screening assessments and the clinical assessment. The case plan really needs to also include proximal and distal goals. I also strongly encourage to make sure that you're using the participants' words, because if you're using the participants' words in that case plan, they're more likely to have a little bit more ownership or buy-in into the case plan. Case plans, to nod to the treatment folks, case plans are different than treatment plans. So yes, treatment plans are going to be completed by your treatment providers for sure. And case plans should also be completed by the treatment court staff. Now, the treatment folks, they have to, per licensing, have their own treatment plan. we should work with the treatment provider to include their goals and objectives. And we should share our goals and objectives and case plan with the treatment provider so that we're all on the same page.
So for case plans, you just mentioned that they should be created by the treatment. Is it the coordinator or the agent? Because as an agent, I create my own case plan based on their criminogenic needs using a driver worksheet as well. And then they're supposed to also create a case plan?
What I would recommend is integrated case planning. So who's all at the table doing the case planning would be the DOC agent, the case manager. A lot of times, like I came from a treatment court that worked with families, so we would also invite the family services worker to the table. And why are we doing that? Because it is more efficient, right? It's also potentially, we won't duplicate service, but it's also not as overwhelming. I mean, if you're a participant and I have 6 case plans that I have to follow, talk about feeling overwhelmed. So I recommend integrated case planning, bringing all of those people to the table. Like I said, though, the treatment provider really does need to have their own separate case plan for licensing. But in those case plans, we definitely want to rank criminogenic needs. Boy, you guys really exercise.
This is where teamwork really works. I mean, you get a release of information from the client or the treatment court participant so that you can share what you've developed with your clinician so that we're not running up against each other.
Exactly. See, I love case planning. Look at all this collaboration and we're just doing training. So in that case plan, we want to define what the participant responsibilities are. I also want to make sure that we talk a lot about responsivity factors, because I think that those are very important to address. If we aren't helping participants address responsivity issues, it's really hard to do matrix group. You know, there are different types of, did I go past it? Yeah. There's different types of responsivity needs. So there's the barriers that are initial barriers. You know, how do I get there? So you may need to look at transportation barriers. Maybe you need to get cab vouchers for participants. You know, there's also physical health. A lot of folks, when they're coming into the court, they were just actively using, so their physical health isn't in the best condition. Dental health. I've had participants, if you've never had an abscess tooth, let me tell you, that hurts. If you don't get that taken care of or help that participant figure that stuff out, it's really hard to sit in matrix group with a throbbing head. So those initial barriers we really need to take a look at. We also need to take into consideration those factors that might impact how they can achieve their goals. Learning style is a big example here. So I am a very visual person. So I need that type of learning style. So I like to ask, or I did, I don't have to necessarily ask this anymore because I'm not direct practice, but I would ask participants, how do you learn? Because if my treatment provider was using mostly all binder work, that would be important for the treatment provider to know so that they could maybe make arrangements to do a different type of format for that participant or guide their individual sessions to be a little bit more interactive for that participant. So those responsivity factors are really important to take into account. Again, we've talked about targeting those criminogenic need areas. We have the big 4 and the lesser 4. This kind of just outlines just general examples. There's way more interventions that are out there. But like if one of the areas of need is history of antisocial behavior, the need area or intervention would be to build and practice positive, healthy behaviors. Maybe you refer the person to MRT. If the person has antisocial personality pattern, they're looking to learn some problem solving skills and practice anger management. Maybe you refer this person to DBT, or maybe you refer this person to anger management. So trying to match what their criminogenic need is and what they're saying about what they need for service. I thought I saw your hand go up, but you just moved. So developing that case plan. There are several different stages in the developing of the case plan. We kind of already talked about the planning, who's all at the meeting. who's all, helping define the goals and the strategies. Then we need to focus on linking. Who's going to do the referrals? What clinic are they going to do it at? What I also really think it's important to tell participants the length of time. So if MRT is X amount of weeks, that gives the person maybe a time frame. If you say you're just going to go to MRT, I'm not sure how long it is, that can create a lot of anxiety. I like time frames, so being considerate of that. Another area is advocacy. A lot of participants that are coming into the doors may be eligible for services that they didn't even know about. So part of the case planning is figuring that out. Maybe we're helping them sign up for food share, Badger Care. Maybe they're a veteran and they've never even applied for veteran services. So trying to advocate for other services that can help that participant. CCS is another good example. Maybe they're eligible for CCS and we can help refer them to that. Part of case planning is also that ongoing communication with all of the service providers. And a lot of times there's a lot of sites that the pre-staff meeting isn't enough time to meet and talk about clients. So a lot of sites do have a practice where the clinicians or the direct service workers meet additionally because they need to talk about those specific case plan concepts. As I said before, there's always the assessment process that needs to, you want to go in and you want to celebrate when somebody completes matrix early recovery skills. Maybe you want to tell the judge that the person completed that because they'll get a certificate of completion in court. That's another great way to build an incentive for that participant. So keeping track of what they're completing and putting that right in the case plan. I know lots of sites review their case plans with the DOC agent at every case management contact so that they can all celebrate it. Or some sites also have their case plan on their staffing reports that they send to the judge, because the judge may be interested in knowing that this person successfully completed MRT. I'm going to acknowledge that in court. So we definitely want to consider updating that case plan at least every 6 months. I really want it to be more, like way more. So please try to do it at least every 6 months and then celebrate with those participants. See, I talk fast. Any questions?
How do you create, I can hear myself. How do you create buy-in with providers who are private practice and not a county provider?
Communication. You talk and education, kind of like what we've talked about before. Integrated case planning, there's benefits for everybody, right? So maybe collaborating with that private provider and letting them know what the benefits would be of integrated case planning and coming to the table. It's in the best interest of the client, strengths-based. All right. Who's 11?
Thank you. I literally just walked into that elephant. I don't know if you guys saw that. Ouch. All right. We're talking treatment. Disclaimer, I'm going to give a disclaimer. I have only been back in the world of treatment provider since Christmas. So I am not an expert. I am experienced, but I will lean on those of you who maybe have been doing this longer than I have to weigh in if I'm off course. But I will tell you that one of the hardest transitions I just made was from coordinator case manager to treatment provider. And I tell you that because treatment providers, if your team members don't know what it is you're doing, teach them. I thought I knew what was happening in treatment. Whoa, was I wrong? I just read a treatment manual from page 1 to the end, and it tells us how to do treatment. It tells us the science of treatment. It doesn't necessarily teach us the art of treatment, but it tells us the science of treatment. And I can tell you that there are probably a number of folks that were sitting on our team that had different ideas of what our treatment looks like. So we have an obligation to educate on what our treatment looks like. Treatment is probably one of the most important components of a treatment court. It's right in the name, right? Treatment court, got it. And we need to make sure that our participants are receiving adequate services and evidence-based treatment to meet complex needs. Folks are coming to our clinics with extreme complex needs. Substance use disorders. You will see me try to switch out the word addiction with substance use disorders wherever I can. People living with substance use disorders are living with complex needs. Relapse. It could be a common part of somebody's journey, but it is not necessarily a part of everybody's journey, or particularly everybody's journey while in treatment court. Relapse may have occurred prior to the time that they came into treatment court. Somebody that gets through your program without a use episode may not suggest that your program's doing something perfectly right or perfectly wrong. That's just what their journey was in the time you spent with them. But the language that we use around relapse or use episodes matters. We do not want to set the stage where we expect this from you and we will be okay with this from you. Okay, we don't want to set that stage. We will be okay. We'll find our way through it together, but we don't want to set that stage of it's okay, it's part of your process, let it happen here. Okay. All right. I got my Fitbit on, I'm gonna get step.
Okay, so if they're having a relapse, just so you know, they're not going to be talking to the clinician, they're not going to talk to the case manager, they're not going to avoid the probation and parole agent, they're not going to appear for court. That's a relapse where they go back into active use and their addictive behavior and thinking. Now, what most of us encounter is a lapse where they have a oops or hit a speed bump. That's where we can change how we think about what they're doing as participants in recovery court, treatment court, drug court, whatever you want to call it. So we really have to really look at our language for that.
Thank you. And once again, I hear side conversations, side comments, all of this is challenging our thinking, right? So check in on those things. Check in. Level of care. Just as it is important to figure out what folks are coming into our programs and making sure they're the right target population, it's just as important that we as clinicians make sure that we are matching their need to the right level of care. And when we don't, that we be prepared for whatever may come and be ready with the response from there, okay? Most programs are probably using ASAM criteria. If you are not a treatment provider and you don't know what ASAM criteria is, ask. It makes a big difference for those of us that are doing clinical work on changes in somebody's treatment plan. All plays out with ASAM. If you're still using the UPC, that's okay for the time being in the state of Wisconsin, but just know that they are working to push UPC placements out of your insurance coverage required pre-authorizations. So it's okay for today, but know that UPC doesn't have much time left in the state of Wisconsin. Also on this slide, another important note, the use of incarceration as a level of care. I promise you ASAM does not have a level of care written as incarceration. There is not incarceration as a treatment response, okay? So if you have somebody who needs a level of care that you are working to get them in, and I will tell you, waiting for residential services, withdrawal management services across the state right now is extremely difficult. Wait times are long. Holding them in jail is not best practice. It's not healthy for them. It's not best practice. Sometimes safety concerns have to be addressed. I get it. But know that that is not a level of care, and treatment providers should be advocating for other opportunities to keep a person safe and provide a level of care until the next appropriate level of care becomes available to them. Treatment plan content. As Marcia was talking about case plans, treatment plans are extremely different, and they're governed by a ton of specific laws and regulations. So if you're seeing things on this slide that don't make sense to you, ask your treatment provider. Ask your treatment provider why a treatment plan looks this way. Ask them why things are written smart. Ask them why they change. Ask them why a goal is to get my probation officer off my back. As a treatment provider, we may not write that, but the language of the person sitting across from us in our office is what matters. Okay. Evidence-based practices, there's that word again, should be incorporated in everything that's happening in a treatment court and everything that's happening in treatment, okay? Here you see trauma-informed approaches in care. Clinics should be working to include those components into all clinical services. Motivational interviewing. You'll see that's a component of almost every treatment manual you will read. Talks about the skill or the art of motivational interviewing. Gender specific. There's a ton of research coming out right now on outcome improvements when we can provide gender specific. Easier said than done, I get it. But research really suggests that it makes a big difference when we can provide gender specific services. Some treatment recommendations that align both with ASAM and your best practice standards. Phase 1 participants should be seen at least once per week by a treatment provider or a clinical case manager. I want to make a note, clinical case manager is actually a clinical term, a level of care term. It's different than somebody who may be in a dual coordinator case manager role, okay? Clinical case manager has clinical connotations, licensure things that come with them. So understand clinical case management and case management by a coordinator case manager are not the same thing. They do often overlap and people are often asked to do both services, but a clinical case manager is doing something in accordance with a clinical treatment plan and should be trained to do so. Okay. We talk about integrated approach. Wherever possible, we want our mental health providers. If we can have a dual provider, somebody who can treat mental health and substance use disorders in conjunction, that's fantastic. It's not always feasible. Oftentimes you may have somebody treating the mental health while you have a substance use professional treating subs. They need to be talking. They need to be working together. Because I'll bet you'll have 2 treatment plans that may be pitting goals against one another if there's not communication. Okay. Bringing in community-based support groups. You'll see in here it talks about phase 2 or 3 because oftentimes we need to help motivate, help participants find their motivation to want to attend. We need to prepare them sometimes. I have to walk in to a door I've never walked through before. How to have a conversation with somebody who's not using might be a skill we need to practice. So it talks about incorporating those in about phase 2 or 3. There are treatment curricula that help facilitate 12-step participation. Not saying you have to use that curricula, but that should be, if a person is looking to get engaged in community support, we should be helping introduce those topics. Our final phases should be focused on relapse prevention. It is not uncommon that somebody who's had a significant period of abstinence moves to your last phase and has a lapse episode because all of their structure just changed. Big, dramatic changes. You drug tested me 3 times a week for the last 9 months, and now maybe it's once a week. I wasn't ready for that. I didn't know that that was my accountability. Now I know. Where am I going to get it now? So when those drastic changes occur, that's when we should be maybe picking up some of our treatment interventions to make sure our folks are ready for living life outside of treatment court. And then continued support for about 90 days discharge from treatment court. Being able to check in, being able to see what those goals were left when they left treatment court. Are they still on track with them? How's that relapse prevention plan working? I skipped a slide. My slides are out of order. I didn't skip a slide. Here are some examples of some evidence-based treatment curricula. Hopefully these look familiar to you. One thing I would like to say about these is I am working in a program that provides matrix, and I'll tell you that I just read the matrix manual from page 1 to page 164. And it does tell you specifically, you could read in each group, you could start at the top of whatever handout it is and read bottom left to right and move on. You will never fill 90 minutes of group reading one worksheet to folks. You just won't. There's an art, a clinical skill that comes along with making what's on the paper relevant to the person in your group or the person in your office, okay? I will also tell you that I personally felt like when I read the fidelity measures for Matrix that they were written by different people who wrote the manual. What the heck is that? Like the manual tells you should have these groups on this day for this long, and fidelity is like, well, do you have 2 groups a week? So finding your balance, finding where you can meet fidelity, where you can make adjustments so that it fits for your population. Because I can tell you that a matrix program being run in St. Clair County probably looks very different than a matrix program being run in Milwaukee. Because we have to adapt for the population coming into our clinics, okay? Again, these are all manualized programs. The person providing these programs should be trained in the provision of these programs. Dosage and intensity. Dosage and intensity is something that you will see over and over again, not only in the corrections world, but you will see it in the treatment court standards written for Wisconsin, but you'll also see it in the National Drug Court Standards. And they're really big numbers, okay? What I would say is dosage numbers are important. They're there for a reason, but don't get too hung up on a number. Trust your treatment provider. Because I could say we're gonna give participants A through F 200 hours and it's all gonna be the same and they're gonna get their 200 hours and they're cured. It's not gonna work like that. Person A may meet their treatment goals at 152 hours. What are you gonna do for the rest of the 48? Okay, it's important as a starting point, but individualized treatment is much, much more important. And I think you'll find I actually just mapped this out. I'm kind of a nerd sometimes, but I mapped this out for Matrix. And Matrix gets, if you run Matrix the way it's written in the 164-page manual, it will get you very, very close to the hours that are required or recommended in the national standards. Okay. If you didn't know, intensive outpatient means 9 hours per week of services for one person. One person should be in clinical services for 9 hours a week to meet the ASAM level of intensive outpatient services. Okay, that can be a combination of groups and individuals, but it's 9 hours. So think about that when you're thinking about your phase requirements in phase 1. If it's important for somebody to get in the door to treatment and they need to be there for 9 hours, what else are you asking them to do? The note I want to make about recovery is just that recovery is an individual journey. We can certainly lay out a phase structure. We can certainly lay out a treatment plan that starts from a cookie cutter. But if we never change it from that cookie cutter gingerbread man, it will work for some, it will cause harm to others. We have to deal with what's coming in and provide something that matches a need. And sometimes we get it wrong. We might guess. Based on what I'm hearing today, based on all those assessments we gather, based on all this information, I think this makes sense. And we do it and they get worse. Okay. We reassess. This is what didn't add up last time. We'll try this. Okay. So supporting somebody in their journey to recovery means allowing them to be an individual in their recovery. This is sort of my soapbox, and I feel like I was up here preaching. Are there other questions or comments about treatment in terms of how it looks in a treatment court? Awesome. With you?
All right, so we're going to talk about program phases, standard 12. So just some important things to know. So dealing with this high-risk population, your treatment court is going to be structured to last for about 12 to 14 months, although not everybody is going to complete your program in that time. Actually, one of the graduates that I'm currently working with, who's going on a little bit of a speaking tour with me, took 3.5 years to complete treatment court. So it is very individual. It works when it works. It's important to remember treatment phases are very separate from treatment court phases. So having something in your program where by the end of phase 1, you're going to complete MRT, that's not reasonable. People complete treatment as they complete treatment. So the treatment needs to be very individualized, but there are other aspects of treatment court that they do need to complete within phase 1, which we'll get into in a second. And those phase requirements are reflecting those proximal and distal goals. So remember, the proximal are things that you think your participant can complete right now, and the distal are things that you are expecting them to complete maybe towards the end of your program. And phase demotion is contraindicated, which once somebody completes one phase, you never want to send them back to that phase. You can definitely make your current phase look like the previous phase, but if somebody has finished phase 1, they don't get sent back to phase 1. So again, risk level, we're dealing with that high risk, high need up in that left-hand corner. And the things that we know works well for that population is a status calendar. So they're coming into the court regularly, that they're attending treatment. They need pro-social and adaptive habilitation. And that means that they do not have the skills yet to be able to function in the world. It's not that they forgot how to function. They never learned it. So you have to teach them those skills. Abstinence is a distal goal, which means abstinence we're expecting by the end of our program. And they respond really well to positive reinforcement, which we'll talk about with incentives and sanctions in a little bit. Self-help and alumni groups are required. And again, you're looking at that about 200 hours of dosage, 18 to 24 months in your program. So now we're going to walk through the phases. These are the national recommendations for phases. Your phases might look a little different just based on the things that you have access to in your community, the resources that you have, the ability that you have to monitor some of these things. It's really important though that your phase structure, if you require somebody to do something, you have to have a way to verify that they're doing it. So if you don't have a way to verify curfew, don't have a curfew in your program because your participants will know you're not checking and it gives them the impression that it's okay for me to break the rules. So if you can't verify it, don't have it in your program. Some of the things that are really important to have in that initial phase is obviously drug testing, which we'll talk about again in just a little bit, but that sobriety time. So the national recommendations in phase 1 are 14 days of continued sobriety, which is verified through your drug testing. Some programs have a little bit longer, some programs we don't recommend shorter than 14 days, but you're building up their ability to stay sober. So that sobriety time is going to increase through each successive phase. You're going to want your folks to be having home visits. You're going to want them to be coming into the office frequently. They might meet with a coordinator. They might meet with a probation officer. And all of that needs to be coordinated with your team. And you're working on getting your folks, your participants to start changing people, places, and things. Phase 2 is the clinical stabilization. So this is really after you've addressed some of those initial barriers and needs like the housing, the transportation, food assistance, those initial things that you're going to have to address with your participants. Oh, sorry. And that initial phase is usually 60 days or about 2 months. Clinical stabilization is really when they're getting into treatment. So they're really starting to make some progress in treatment. They've stabilized a little bit. So some of the things are going to start to back off. So you might start to have maybe fewer office visits, not usually in the second phase, that's usually a little bit later, but you're going to start adding some additional things on them. So maybe you're going to start to address some financial needs during phase 2 because they're a little bit more stable and they're able to have that conversation. You're going to, if you are enforcing a curfew, maybe that curfew gets extended a little bit now because they've built some trust and they're doing what they need to be doing. That sobriety time, again, is about 30 days in phase 2. So we've jumped from 14 days to 30 days. And this phase is generally about 90 days, about 3 months. Then we're moving into pro-social stabilization. So this is really where we're trying to get our participants out into the community and they're starting to attend AA, NA, Smart Recovery, those types of community support groups. Maybe you're backing off court now. So maybe you're down to a monthly court visit. You're maybe again establishing a later curfew. And this is really where they can start to address some of the criminal thinking. So programs like T4C, Thinking for Change, or MRT, this is often where it gets introduced into the program. Your sobriety time is going to go up again. So you're at 45 consecutive days of sobriety. And this phase again is about 90 days. The one thing that never changes through any of your phases is drug testing, which we'll talk about in a little bit, but I want to throw that out there. It's always there. Then we're moving into adaptive habilitation. So this is where you're looking at pro-social activities and they're starting to maintain the recovery network. That curfew again is getting a little bit later. And this is really where you're going to be looking at job training. Maybe they need parenting skills. Maybe they need some vocational training. Maybe they want to go back to school. All of those types of additional skills that you're going, or ancillary services that your participants might need. That sobriety time again is increased to about 60 days. And this phase is again at 90 days. Shocker, all the rest are at 90 days. So then phase 5 is that continuing care. So here's where you're looking at that relapse prevention plan. This is right before somebody's getting ready to graduate from your program. So you're looking at 90 days of consecutive sobriety. During this time, they're still doing the random drug testing right up until graduation. Really just a few weeks before graduation is when you want to start to taper off some of that drug testing. They're developing their continuing care plan. And By this point, hopefully they're fairly stable. They probably have a job, or maybe they're in school, depending on what their personal goals are, but they're fairly stable and you're fairly certain that everything's going to be okay. And they have a plan in place in case things go haywire. So you want to make sure all that information is included in your participant handbook. Your participants should be very aware of what the expectations are in each phase. It just needs to be laid out. And all of your participant handbooks, my goodness, should be written in behavioral terms. So if you have a requirement in your program that they maintain stable housing, what does stable housing look like? Your participants need to understand that. That's it on phases. Any questions on phases? Good, because I'm getting tired. I don't know about you guys. All right, so we're gonna bust through drug and alcohol testing, which is one of my favorite things to talk about. So I do kind of hope there's a few questions, but then after this standard, we'll take another little bit of a break and then we'll come back and finish out the day. So drug and alcohol testing. So this is really the cornerstone of your treatment core program. If you do not have reliable, valid drug testing, you do not have a treatment core program because you do not know what your participants are up to. And this is the only way we have to verify what we're doing is working and the treatment is working and we are addressing the right needs. Best practice for drug testing is UA testing twice a week, totally at random. So that means on holidays, weekends, they still have the same chances of being called for a UA. You want to test as often as you can and for as many substances as you can. So if you have somebody who comes in, their drug of choice is cocaine or meth, whatever it might be, I know you all will be shocked that sometimes people switch to a different substance. And if your participants will talk, so if they find out that they didn't get caught in a UA for whatever substance they might have used, pretty soon all of your participants will be using that substance. So test for as many things as you can. All of your UAs need to be observed. If you're not observing your UAs, they're worthless. You don't know if they're cheating. It's just worthless. Don't bother. So if you can't observe your UAs, try and use an alternative testing method. So things like oral swabs, sweat patches, those types of things. If you can't do observed drug testing. Become super familiar with their drug detection time. So, certain drugs are in and out of your system very quickly, where other drugs last longer. So just make sure you're aware of that and make sure that your participants are aware of all the policies and how to request confirmation testing if they need. It's important that you're looking for adulteration and tampering. You can see over on the left, those common types of adulteration. I can send you many pictures if anybody's interested in what a Wizinator looks like or any of that kind of stuff. But there are certain protocols that you can put in place. And the biggest thing to avoid the tampering is to have observed UAs, have somebody watching, even though that's super uncomfortable. Make sure, try and limit the amount of fluids that they can consume so they don't dilute their sample. So I know when I was a coordinator in Columbia County, we had our participants test right away in the morning in hopes that they wouldn't be able to drink enough water to dilute their sample right away in the morning. Time limits are important. Make sure that once your participants are called for their UA, so maybe you have a call in line, they find out I have a test today, that they don't have too much time to think about it. So you don't want to find out at 9 o'clock in the morning that you have a test and you don't test until 6 p.m. at night. They could have done a lot in between that. Have your participants wash their hands before they produce because they could have powders on their hands, things like that. And then you're going to want to observe that color, appearance, odor, temperature, pH, specific gravity, and creatinine levels. And a lot of your instant read UA tests will have all that information on there. So you want to make sure that your samples are defensible in court. And remember that false positives and negatives will happen. I shouldn't even tell this story in this room, but my husband is Czech, and they have these things called klatschkis, and they're little buns. And one of the favorite ones is poppy seed, and they're just stuffed full of poppy seeds. And so we were messing around with my UA test, and my husband ate 2 of those and tested positive for opiates for 3 days. So, and I'm pretty sure he's not using anything. I can't be 100% sure. So just make sure that you have a procedure for confirmation testing. False positives and false negatives definitely do happen. And make sure your participants can dispute those results, and you don't want to sanction anybody for a positive test without that confirmation test or an admission. So in focus groups, treatment core participants regularly identify drug testing as one of the things that help them the most throughout their program. And the more frequency you can perform those tests, the higher graduation rates you're going to have out of your program. It's super important. I can't stress it enough. So does anybody have any questions about drug testing? Yay!
Also, two things to think about. If you are a program governed under your Department of Health and Human Services, so if your staff are part of Department of Health and Human Services, there is language about CLIA waived products, CLIA waived laboratories. All that means is that your laboratory, your product has been tested enough that the frequency of false positives is very limited. It says if you are going to make decisions about somebody's civil liberties based on a drug test result, it must be a CLIA waived or CLIA approved product. Check it out. Just Google Wisconsin DHS CLIA. You'll find it. Number two, if you think that your treatment provider's drug testing is sufficient to replace your treatment court testing, it is not. We test for different reasons and purposes in treatment, especially if your treatment is a contingency management program. Okay, we don't meet all of the standards of treatment court testing in a clinic. We test for different reasons. Similar, but different. So do not take a treatment test to replace one of your own required court tests.
So on our team, we've had some struggles with agreeing on the validity of sweat patches. So do any of you board people have something to say about that?
So, I will say there's a lot of research out there, and I'm happy to send you studies on the validity of sweat patches. They are valid. They are legally defensible. And I'm sure I can put you in contact with some people that would be more than happy to talk your ear off about sweat patches. We've used them. Have you guys used them in your program? I honestly never had somebody test positive on a sweat patch, for what that's worth. But they definitely are valid and legally defensible, and they are happy to come and testify in your treatment court hearings if you'd like. Oh yeah, that costs. All right. But the same is true. UAs aren't perfect either. Oral swabs aren't perfect either. Blood testing's not perfect either. So just know what you're getting into with whatever testing you're using. Any other questions? What time is it? All right, so we're going to give you a 10-minute break, but you have to be back here in 10 minutes. Yeah, and the next thing is incentives and sanctions. So I am not kidding. screwed this up again. I just started sharing all by myself though. I started sharing and all that all by myself, but I screwed up the clicker. And I hit record. Yeah, I screwed up the clicker. Interesting. I know, I know. Oh, it's all frozen again. Yeah, I think you have to click on it. Like wakes it all up or something. Oops. Oops. All right. Yeah, that's fine. All right, we're gonna get started. Incentives and sanctions. We're gonna start. I'm probably deafening the people online. Sorry. Sorry about that. All right, so we're going to talk about incentives and sanctions and behavior modification. So some of you, when you walked in the room, when you came back, got a piece of candy from me. So if you did receive a piece of candy, please stand up. You're all part of my experiment. Just kidding, stand up. Keep standing, keep standing, keep standing. All right, so some of you, I had the box of candy and I said, please take a piece of candy, or would you like a piece of candy? If you were one of those people that I said that to, kind of wave at me. So why did you get a piece of candy? I feel like you took a big leap there, but all right, I'll give that one to you. Some of you, when you walk back into the room, I said, thank you for coming back on time. Here's a piece of candy, right? So I tied your behavior to what I was giving you, right? Some of you, I gave a choice of what you wanted out of the box. You can sit down, sorry. Sorry. Some of you, I gave a choice of what piece of candy you wanted to pick out of the box. Some of you, I just handed you a piece of candy. Some of you, I purposely didn't give a piece of candy to when you walked in the room. So if that was you, and I think it might have been you two ladies in the front. I think it was you. I can't remember who I skipped. Sorry. How did that make you feel? Oh, she was multitasking and working, so didn't pay attention. So you noticed that you didn't get a piece of candy, but other people were? Oh. All right, well, we won't be doing this exercise again. Thank you. So the point is to, yeah, hopefully when we go through this standard, eventually it'll all make sense. I don't know. I'm just going to move on. All right. So our participants are going to be at all different stages of change in their process in treatment court. Your participant can be at any one of these stages at any time. They can also be in pre-contemplation, jump to action, move back to contemplation. They jump all over the place. And the focus of your actions in treatment court is to focus on moving your participant from one stage to the next stage. So you're going to have some people that come into treatment court and this is stupid. I don't have a problem. Drugs aren't an issue for me. I can stop anytime. Okay, well, your UAs say otherwise. So how are we going to get that person to move into that contemplation stage of, oh, maybe drugs are kind of an issue for me? And remember, the goal is to move them into the next stage. So what works with behavior modification? Contingency management, so receiving incentives for meeting goals. Then looking at that proximal and distal goal again, what can your participants achieve right now and what do we need to wait for them to achieve? And those distal goals are going to become proximal goals the further your participant moves into the program. So eventually abstinence is going to be a proximal goal, just not right away in your program. And then graduated incentives and sanctions. So you're going to want to try to avoid using your most severe sanction or your biggest incentive for behavior. So you're avoiding the habituation and ceiling effects. Once you throw somebody in jail, they've been to jail. You don't have any place else for them to go. Once you throw out your biggest incentive, there's nothing else for them to work. Well, there are things for them to work for, but you don't have any other option to give to them. So you're going to want to make sure that those are tied to really big behaviors that you're seeing, positive or negative. So behavior modification in treatment courts, sanctions decrease behavior, decrease the behavior you don't want to see. Incentives are increasing the behavior that you do want to see. Therapeutic adjustments are treating the behavior that you see. And supervision and drug testing is monitoring the behavior that you're seeing.
So we've had a few participants where, and we've got one now, he is doing everything he's supposed to be doing. He is not embracing the program. He complains constantly about what he has to do, and he really doesn't have a problem, but he meets all the criteria. And so how do you deal with somebody to get them to quote unquote drink the Kool-Aid?
Well, are they making progress in your program? So Kim, you can correct me if I'm wrong, but work with your treatment provider. So look at the motivation, look at the stages of change, all that kind of stuff. But sometimes it's just noise. If they're making progress in your program and they're not using drugs and they are going to treatment and they are doing MRT and they're doing everything they're supposed to be doing, let them be loud. I mean, if they're not really making changes, you're going to find out. So some people just are loud. So with behavior modification, you really need to be able to reliably detect behavior. So if I use drugs, I know I'm going to get caught. It's certain that I'm going to get caught. That's with your drug testing. And then you need consistent detection. So you want to connect behavior with an immediate consequence, incentive or sanction, positive or negative. Remember, you're trying to get that red fish to swim against all the other blue fishes that are going the other way. A little bit about fairness. You guys can see on the left, everybody got the same thing, but two people still can't see the game. Where over on the right, everybody got what they actually needed and everybody can see the game. They should pay for the ticket. All right. But this is really important concept in treatment court. Your judge is going to have to do a really good job of explaining why people are getting different responses to different behaviors. It may, Kim and I may be in the same program. Kim and I both have a positive drug test. I might get a very different sanction than what Kim might get just based on where we are in the program, what led up to the violation, all that kind of stuff. So it's important for your judge to be able to explain why people are getting different things in court and your coordinators and everybody else. So keep in mind, understand this is about them. It's not about you. So some incentives and sanctions that might work for you will not work for your participants. I don't know, I've heard many times, from different practitioners about, well, why don't they just stop using drugs because they're going to go to prison? They don't think that way. So it's about them, not about you. So considerations when you're in staffing, you're going to be looking at who they are in terms of risk and need, where they are in your program. Why did this happen? What's the story? What were the circumstances? especially if you're dealing with a lapse, if you're dealing with somebody who had a recent use, was that use expected? Did they just hit on something very traumatic in therapy and yep, we saw this coming a mile away? Or was it something that they just went to party with their friends and didn't even think about it? Which behaviors are you going to respond to? Are they proximal or distal? What is the response that you're going to have? And then how are you going to deliver and explain the response? And then you're always looking at supervision or drug testing changes if you need to increase, decrease treatment, supervision, increase, decrease testing, all those types of things. So applying incentives and sanctions, sometimes it's appropriate to withhold a sanction to reward positive behavior. So maybe you had somebody who had a lapse, but they did all the right things. They contacted their case manager. They said, you know, this is what happened. I screwed up. I'm going to contact my treatment provider. I did everything I was supposed to do. You may withhold a sanction to reward or to incentivize that positive behavior that you saw from that participant. Another time is you may have somebody who misses, say, late to a treatment appointment. The judge might say, okay, normally you 10 minutes late to a treatment appointment. Normally we would have you do some community service hours. I'm not going to have you do community service hours this week. So if you make all of your treatment appointments for the next 3 weeks and you're on time, you won't have to do your community service hours. But if you don't make your appointments for those next 3 weeks, you're going to have to do the previously imposed community service hours plus additional community service hours for the additional violations that you rack up during those 3 weeks. Remember, failure to address the positive behavior decreases the likelihood it will happen again, and failing to address the negative behavior condones it, which is when we were talking about curfew. If you're not addressing them breaking the rules, you're saying it's okay for them to break the rules. You want to make sure that your infractions, incentives, and sanctions are all clearly defined in your participant manual. Participants should know what they can and can't get in trouble for, and they should know what our menu of incentives and sanctions are that we can apply in the program. Always consider needs and responsivity factors when you're applying incentives and sanctions. So if you have somebody, say, who does something just phenomenal, or maybe they're getting close to graduation and you want to reward them with a trip, say, to Kalahari so they can take their kids to the water park, but they're terrified of the water, probably not a good incentive for that participant. And then you also want to look at noncompliance versus non-responsiveness. Are they just not doing what we asked? They have the ability to do what we asked, but they're just choosing not to do it? Or can they not actually do what we are asking them to do? Do they not have a ride to treatment? Do they have some sort of mental illness that's keeping them from actually walking through the treatment doors? So just making sure you know it's non-compliance versus non-responsiveness. I was in a training not too long ago, and the speaker was talking about that they had a parole officer, and every time he was meeting with this person, he would look out the window and he'd see the guy outside, like he was coming to the appointment, and the guy would never come into the building. So the parole officer was getting ready to revoke the guy's parole, and when they finally had the conversation about why aren't you coming into the building, it turns out the guy's brother was killed on the corner, and he couldn't physically force himself to walk across the street. So just non-responsiveness versus non-compliance, super important. Importance of incentives, incentivize everything you possibly can. You're looking for a 4-to-1 ratio, but if you can get that up to 10-to-1, 12-to-1, 100-to-1, you're going to find better results. So incentivize everything you possibly can. The next couple of slides are from an EBDM work group behavior response matrix or behavior response guide. You can find that on my website. I'm happy to send it to you if you'd like. That was done under the state CJCC, and it's based off the DOC's response to violation matrix that they use. So this is just a way of looking at violations, behaviors to figure out where our response should be, what our magnitude of response is. So you're looking at, is it a proximal or distal goal? Is it the first time I've seen this behavior, or is the behavior being consistently displayed? And then what type of behavior is it? So is it participation behavior? Is it engagement behavior? Or is it a public safety or pro-social behavior? Sorry, I'm on incentives. Those are good things. And you're going to incentivize those behaviors appropriately. Same with sanctions. So you're looking at participation risk, sobriety risk, or public safety risk, and you're gonna sanction those behaviors appropriately. You're also going to want to look at aggravating and mitigating factors. Is there something that made this behavior a little less terrible, or is there something that makes this behavior a little worse? So maybe it's a chronic pattern of violations, you're going to escalate those sanctions. But like I talked about before, if the person comes in and is honest about whatever's going on, maybe you're going to make that sanction a little bit less to incentivize that positive behavior. Then you're going to determine the response. This is a couple-page document that's at the end of the EBDM guide. These are different responses, incentives, and sanctions that we've seen throughout the state. If you read through this document and you have one that you use that is not in there, please let us know. We'll add it to the list, but you're going to want to go through and create a similar incentive matrix and a sanction matrix for your program, just so you can figure out what that magnitude is for each of those incentives and sanctions and how to respond. It makes your conversation go a little bit quicker in staffing. Fishbowl, how many of you guys have a fishbowl? I would bet you every one of your policies and procedures around that fishbowl looks different. So it can include a variety of low, medium, and high incentive value incentives. It's super important that it's reinforced by the judge. So at the end, if you do it at the end of the court hearing, you want to make sure that the judge is still on the bench and court is still in session when that fishbowl drawing is taking place, that it's not an afterthought. It's been shown not to trigger gambling behaviors. Sometimes that's a concern, but it has been shown that it doesn't affect that. Fishbowl, like I said, is different from program to program. Some programs draw names out of the bowl. Some programs put names. Everybody who's eligible for the fishbowl gets to draw a prize out of the fishbowl. The procedure looks different everywhere. So if you have questions about it, please ask. We're happy to talk about it. Remember, for sanctioning, punishment's never the goal. It's what do you want them to learn from the sanction? What do we want them to do differently? What are we trying to teach them? And again, phase the motion, we talked briefly about that, should very rarely, if ever, be used. Once they've completed a piece of the program, they don't go back to do it again. You can definitely, like I said, put them in sort of a phase hold, or make that phase look like the previous phase, put some of those structures back in place, but they don't actually go back in your program. In jail sanctions, often not effective, can be super disruptive. It can often make your participant situation worse if they have some of those stability factors, if they have kids, things like that. So if you do have to use a jail sanction, you want to make sure it's for illegal activity or a public safety concern. And if you can, you want to make it as easy as possible for your participants. So if they do have work, okay, can you call and talk to your boss, you know, and take off Friday and Saturday because you're going to go spend the night with the city's finest. So just trying to make sure that you're as accommodating as you can be. However, we of course understand sometimes you're going to jail and that's just how it is. And this is just a study that was done a while ago just about jail sanctions and how ineffective they are. So you can see after about a week, the recidivism goes through the roof. Any questions on incentives and sanctions? And I apologize that not everybody got a piece of candy, but hopefully you now see the point of the exercise we will never do again.
One thing that Heather forgot to mention with the incentives and sanctions is we do actually have a hands-on incentives and sanctions training. Somehow it took on the name Hoist because those are the letters that I just read off to you, that we will do with your team and your team individually virtually. So all of those grids and all of those things that Heather just went through rather quickly, you can request and our team will connect with your team virtually and walk you through that grid, as well as some case scenarios that you can practice alongside of some of our team to help that become more familiar for you. Okay, I know what time it is. You all know what time it is. We're talking about training. Here's the deal. You're here, you're in the room, you're virtual, so I think you get it, okay? Ongoing training is essential. Why? Because as soon as you figure out one best practice standard, they write a new one. Or they erase the one you just figured out and say, whoops, we had that wrong. We're going to do it this way now, okay? So training is a super essential component to make sure that you are delivering the most up-to-date blueprint in your court and that we are not doing harm. I think I just said all of that. What's important to know though is that sometimes non-treatment court specific training is also just as valuable. So making sure your treatment providers are up to date on what's happening in the world of treatment, making sure that your law enforcement providers are up to date on what's happening in the world of community supervision components alongside of their DOC partners, making sure that you're up to date on drug trends, new names, because heck, if as soon as we figure what those are, they come up with 5 more. Staying relevant on things that are not necessarily specific just to treatment court shapes your knowledge in general. When it comes to new team members, and every team goes through a period of time where you get new team members, you need to take a look at how are you training those new members? Are you handing them a copy of the handbook and saying best of luck? See you Wednesday? Do you even have a handbook to hand them? There is training out there specific, we've mentioned it before, about the roles that you can find online. We can do them here. You need to make sure that you are offering that to your new team members. Sometimes it's not always possible. That bridge where you can take a team member who's leaving their role and have them train in the new person that's coming in would be fantastic. Doesn't always work that way. So making sure you have something available on training your new team members, and then making sure that that's documented. Audits come along. You want to make sure you have documentation of the training that you did as a professional and the training that team members did. Those are important questions that are asked by grant administrators and other important folks. Here it is. When you participate in training, it has significant impacts on the outcomes of your programs. When all team members participate in formal training, 57% greater reductions in recidivism happen in those programs. Okay, this is how important it is. And again, it's because we're ever evolving. The research says one thing one day and the research says something else the next. We need to stay on top of it. Here are some of the resources for training. Heather has a phenomenal list on her website. Actually, even links I think you can click to get to most of these websites. There's also a training calendar that she has out there that will tell you what's coming up, what's new, where you can find it. I highly suggest checking out her website and any of these. My final note is a quick pitch for WATCP. We are a board of members of folks sitting in this room. There are probably other board members. I see board members in the room. We don't know what to bring you if you don't tell us what you need, but our job is to bring training to you. So if there is a specific topic that you would like to see covered, let us know. Feedback surveys will be out all week. What can we do better? What topic caused you that moment? What do you want to learn more about? We will do our best. Heather has some phenomenal connections with our national partners. She can get them here. Just tell us what you need. Is there a question? Oh, yeah.
I just wondered if Tad, I'm looking at you, if Tad is thinking about, or if it's a possibility to have increased percentage of what our TAD grants can be for training, because right now with our grant, like I couldn't even budget to have as many members of my team that wanted to come to this come because of the restrictions in the grant.
Hi, I'm Melissa. It's nice to put a name and a face together there. So, yeah, actually, we are considering that. We're considering a lot of things as we look ahead to 2023. Many of you know that we have additional money, and so that's going to give us some flexibility that we haven't had before. But I'm glad you mentioned that, because one way to get that to change is to just relay that there's a lot of folks out there who really need additional money for additional training costs. So are we doing it for sure? No, I can't say that for sure, but I can tell you that we're looking into a lot of changes or considering changes, and that would be one of them. So thank you for bringing that up. So other questions? If not, we move on to number standard 16. And I think that's you, Marcia.
Well, and luckily I'm a super fast talker. So so community outreach is really a lot about communication and collaboration and connection. So community outreach is collaborating and connecting with not only your current stakeholders, but also other community members, resources, such things. We want to do community outreach because we need to gain support for the treatment courts. Also, we're talking about sustainability. Grant funding doesn't always last forever, right? Not saying anything. Grant funding isn't always going to sustain the program. So having community outreach and buy-in will potentially help you in the long run. Also, community outreach hopefully will decrease negative bias about substance use disorders, and it promotes recovery. So how do we do community outreach? We talk, we go to meetings, we go to faith-based partners, we go to civic organizations. We also, I love tracking data. We track data because sometimes other community partners are going to be interested in other data points. The example might be sharing with community members how many participants are employed at graduation, how many are now paying taxes, how many are now paying child support. All of that information can be shared with some of those community members and could help encourage buy-in to the programming of the treatment courts. So communication, connection, and just getting out there. So questions? Told you it was gonna be fast. Yeah, because you know what? Mike's up and he's talking about performance and data, and we need time for this. Yes, we do.
All right. Usually there's nothing that guarantees people heading towards the exit as a discussion on performance measurements and evaluation, but we'll give it our shot here. Thank you for hanging around this long. This will be quick. Yes, the standard on this topic isn't always the most popular, but it's an incredibly important one for most of you. I'm sure you understand that. It really involves collecting data, doing analyses, really for the purpose of defining, assessing if a program is meeting in alignment with standards. You've heard so much about the 10 key components. Also, obviously, we're talking about our 17 state standards for treatment courts and as well as the national standards. We need to have some way of finding out if our programs are meeting those standards. And that's what evaluation and performance measurement is all about. They're two separate concepts. Think of performance measurement as an ongoing process in real time to obtain data to find out how the program is functioning. So it's much more of a process-oriented approach, whereas a program evaluation is much more periodic, a little more hands-off, if you will, which really, it's more formal. It's really looking at what's going into a program called, the processes, the inputs, and then assessing what's coming out of the program, outputs, outcomes, the impact. And that really connects with your goals and your objectives that you're reciting when you apply for a grant, for example, or if you're just laying out a series of goals and objectives for your county, so you can define what success is. But there's a lot of commonality between the two. We've kind of given the reasons here. We want to understand how a program operates, how it's been implemented. What are some of the successes and barriers that you're facing as you implement a program. We want to do program refinement, identify areas for improvement, that quality control. You want to find out what you're doing well, what you're not, and make improvements as a result. Obviously, you hear about informed decision making on all fronts. Well, we can't be informed decision makers if we don't have information, and that's what data is. Information on how the program operates, what are the outcomes that we're achieving from our program. And the last quadrant is about seeking and obtaining, justifying expenditures, budgets, funding, getting, it's one thing to get a grant, it's another thing to get your county board or your tribal council to approve funding for your program year in and year out. So those are all reasons for doing performance measuring and evaluations. Just make a quick comment here, tip of the cap to the Wisconsin statewide drug and hybrid court performance measures report, which is available at the website. If you have access to the your slide, you can see where you can get it through the Wisconsin courts office where Heather works. That gives a whole slew of performance measures that you can consider for your programs. Heather's office has been working really hard to help develop specific performance measures that can be used for different types of specialty courts, which includes our OWI courts, veterans courts, as well as mental health courts. So it's all good stuff. Real quickly, we have different types of measures for different type of purposes. So there's outcome measures, which is kind of the quintessential. How many folks are recidivizing now versus had they not been in the program at all? The more process-oriented processing type of measures that, you know, the example we talked about earlier was the processing time. How long does it take to get a person from the time that they were apprehended for the conduct to actually getting into the program? That's more of a process measure. The procedural fairness, the perceptions, the survey results give you that kind of measure. The dosage measures, the amount of treatment a person is receiving, the number of incentives and sanctions that are being dispensed to participants in the program. And then finally, social functioning, it gets more into the skill level of our participants, the level of independent living, employment status that they're achieving now versus what they where they were at when they were first in the program. When you develop a process for data collection, again, this is just like any other methodology that you develop for the direct services, but here you're developing who's responsible. And that's so important that we say twice, who will be responsible? I didn't catch that until now. For collecting the data or the report or system from which the data is currently available, you need to define that, as well as the frequency of collecting data. Now with the core program, those of you with TAD grants know that we collect our data into the core platform, and we're asking you to collect data frequently. In fact, we'd like you to report that as within 48 hours of the event itself that the data's generated from. So these are all things you want to consider as you develop your evaluation plan. There's different types of evaluations and questions that come up here. I don't have time to go through them all here, but again, we were talking about process type of questions, as well as outcomes, you know, is the program meeting the stated goals, the impact on the traditional justice system, the criminal justice system, and that gets into the cost savings that we're achieving, the public safety that we're improving as a result of our treatment programs, cost benefit analysis, you know, how much money are we putting into the programs and what are we achieving coming out of that? You know, for those looking for some help with that, if you're doing anything like that on a local level, please feel free to reach out to me. We have a cost benefit study from 2008 at the state level that would give you some excellent ideas for how you can do that, scale down at the local level. Some of the programs that we fund have done an excellent job of partnering with their local university or an independent experienced evaluator to do some more formal evaluation. You can use TAD money for that purpose. That should be something we again would be able to fund in our next upcoming round of competition. But it's, you know, it's really important to, especially if you got money that that's laying around that you weren't able to use because of the slowdown in services with COVID-19. It's an excellent use of our grant money and perfectly allowable. So, and then again, we want to just kind of repeat all the things about data and evaluations that are important. The reliability of data, is it consistent? Validity refers to, is the data telling or measuring what it purports to measure? Is it answering questions that we think it answers? It's got to be a timely data. And again, I mentioned before with core 48 hours, the accuracy of the data, the relevancy of it are important factors. And then electronic. Hopefully everybody's now in an electronic digital stage in their local data collection. If you're not, you know, we can talk further, but electronic really speeds up the process and the capability of analyzing your data. The collection points that we really are focusing on with core and other evaluations, you know, we're really focusing on the data that we collect at the referral stage, the screening stage, so we can get at the number of people being referred and being successfully qualified for the program. That's what, and then we get to the admission stage. What number of people are getting in? What kind of backgrounds are the people who are in the program? You know, socioeconomic wise, racial, ethnically, demographically. There's a lot that we can learn at that stage. And then, of course, during the program itself, we do a lot of analysis and data collection based on the use of incentives and sanctions, how long it's taking for persons to advance to the different phases, different levels, and the testing results, the drug testing results, how's that looking? And then finally, we get to the discharge stage, you know, what number and percentage of people are graduating successfully, or being terminated as unsuccessful, or having to be discharged for other administrative reasons. So there's a lot of stories that can be told with the data based on these different categories. So I do not have any data to show you right now. However, on Friday, one of our breakout sessions is featuring our core data platform, and we'll have some data there. And if you want some data, we certainly can provide you with that, as well as with reports that are based on our core data collection. So sorry, we don't have any to share today. I'm just going to quickly pop to the next slide, which may be core. CORE stands for our Comprehensive Outcome Research and Evaluation Reporting System, which was developed several years ago within our Department of Justice for the purpose of collecting data for TAD programs and other drug treatment court programs across the state. It is a performance measurement platform. It is not a case management platform. It's available for use at no cost to our grantees, as well as other treatment courts in Wisconsin. As I mentioned before, it tracks persons throughout their participation, throughout their stay, if you will, in drug treatment courts through discharge. And you should contact myself, Marcia, any of us, if you want to learn more about CORE, or better yet, go to the workshop on Friday morning. You will learn a ton more about CORE and all the good work that they do. Last thing I want to leave you with is, if a program had looked at their data, considered it, and made program changes, modifications based on that data, it leads to better results and outcome in terms of better, lower recidivism rates. And so the point being that if you use data, and one purpose of that is for quality improvements, and make changes, you tweak your operations, chances are you're going to improve your outcomes. Your participants are going to do better as a result. So one more reason why to keep data, collect data, and analyze data. So I think we have reached the end here. Are there any final questions? If not, I'll hand it over to.
Thank you, guys. I'll make this really quick because we added a little extra time. I just want to say what we presented here today are standards, right? They're the blueprints. They're sort of how do we put this into work in the work that we're doing day to day. And some of them feel darn near impossible. You read some of those 50 days from arrest to program admission. Some of you are rocking that. Some of you are like, what? We're 2 years. Okay. What you need to do is have these discussions and have frank discussions in your team of what is our standard? What can we reach and what can we be okay with? And when you get there, have that conversation again. We're here now. Can we raise it from 8 to 10? Can we get 10 out of 10? Or is this the best that we can do? The important part is, though, that you're having these discussions, you're reviewing these standards, and you're helping them guide you in all of the work that you're doing. Before we finally send you on your way, I promise that'll be next. I just want us to give one more round of applause to Heather. This is her work in the Director of State Courts office. Wouldn't be possible without her. And we are all here throughout the entire conference. So if something came up today and we don't connect tonight, find us. We'll be here. We're happy to answer and happy to help. Have a great night, guys. Thanks for hanging with us.